item 31 of today's list, my lord. Then appeal in the
Yes, I am for the appellant, my lord.
as respondents, we have also filed one appeal, Lordship. Lordship will finally recollect that on the other day, I moved a petition for condonation of delay of 6 days. Lordship has fixed tomorrow. So my humble prayer, my lord, let both the appeals come together afterwards. My filing number, I can give my lord.
Okay.
And if,
Because against the same judgment, my lord.
When do you want?
yes, my lord, after vacation.
Okay. On request by the parties. Please this matter. Along with
Along with 14464 of 23. Lord.
Filing number.
Yes, filing number. Lord.
you got it. On 30 January.
13th January.
13th, after vacation.
30. Oh, 30. My lord. About 30, my lord, it may not be, my lord. It may be any other 29th, my lord.
29.
Made to the notary. Lordship, in item number 46, we have filed an affidavit that may kindly be called for. Affidavit was filed yesterday with regard to justice service law. Lordship.
Good morning, madam. I would like to mention for listing of my writ appeal, the filing number is F/S 14098,
That has not been numbered yet.
numbered here. And this is, the hearing of this is sine qua non for the disposal of my whole appeal, which is to be listed tomorrow.
What?
Tomorrow.
Writ appeal is not listed, not numbered. Writ appeal has not been numbered. How can we list it tomorrow? Let it be numbered. Is there continuation application along with the writ appeal?
If the hearing of it is sine qua non for the disposal of my writ appeal, which is going to be listed tomorrow. This IA has been disposed and allowed. My lord allowed the IA, and now it is for the
What IA? IA for what?
IA for the delay of 10 days
Then?
in filing the writ appeal.
So that has been allowed.
Allowed, lordship. My lord allowed it. Thankfully.
Then it will be registered and it will be listed in its usual course.
But the hearing is very important for the disposal of tomorrow's cases.
Tomorrow, what cases are there?
Writ appeal 151 of 2023, 152 of 2023, 154 of 2023.
So let those writ appeal come up tomorrow, then we'll see the matter. We'll see after that. Today, we're not allowing anything. Let the writ appeal come up, we'll see tomorrow.
My lord, thank you.
May it please your lord. So I beg to mention item 14 to 28 of today's list, my lord.
40?
14 to 28, my lord. Because here I'm praying for an adjournment on behalf of the respondents, my lord. I appear on behalf of the respondents. My lord, we have taken the consent of the state as well, my lord. My lord, we pray an accommodation, my lord, for the day, my lord.
Who appears for
Yes,
this?
sir. We have taken consent from us, madam.
Okay, Hurt MS, MD Bora.
Lordship.
Additions in your
Lordship, the junior government.
Okay, government advocate for the appellants. On request made by Mr.
H. Pitala, my lord.
H.
Pitala.
Etala. Then council applying for respond number one,
My lord, respondent number one in all the matter.
respond number one. When do you want?
My lord, may it be on 1st of February. It's convenient to
Yes.
my lord. My lord.
On 1st February.
Deeply obliged. my lord.
May it please your lordship. I beg to mention item number 126 of part 2 hearing list, lordship. Lordship, if possible, lordship may kindly take up the matter tomorrow or any other day after Bihu vacation, lordship. Some urgency is there in this case, lordship. I am for respondent. Salary has not been, petitioner, respondent is LP school teacher, lordship, and her salary has not been
25th
25th February,
January.
January of last week.
Item one for motion.
May I please, your lordship? Lordship, as per last order, lordship, this honorable court directed the petitioner to submit 25% of the outstanding amount, lordship. So petitioner has submitted the 25% of the outstanding amount on 30/12, lordship, December. So I have filed, lordship, additional affidavit regarding this, lordship.
Where is your additional affidavit?
Additional, but it is not on record, lordship. Yesterday I have filed it, lordship. So, lordship, kindly fix another date and with this additional affidavit, lordship.
When did you pay your 25%?
30 December, lordship.
30th of December.
30th December, sir, lordship.
Anybody for the bank? Okay. Mr. N.A. Klaska,
Yes, lordship.
Learner Council for the petitioner submits that the petitioner has deposited 25% of the outstanding dues to the respondent bank on 30/12/2023. Stop. He also submits that he has filed an additional affidavit to that effect.
Yesterday, lordship, I
To registry to verify and place the same on record. And this is the matter again on. When do you want?
1st February. Highly obliged.
Item two.
I'm the petitioner in person, lordship.
What is your case?
Lordship, on July 2021, the government of Assam has constituted a cabinet subcommittee to identify the indigenous Assamese-speaking Muslim of the state with the object to uplift their socio-economic status. Thereafter, on 2022, the subcommittee has submitted its report, identified 5 subgroups of Muslim community who are living in the Brahmaputra Valley as an indigenous Muslim, Assamese-speaking Muslim. And subcommittee has suggested certain recommendation for upliftment of their socio-economic status. And I have challenged the suggestion of the subcommittee and the decision of the state cabinet to conduct a survey on the indigenous Assamese-speaking Muslim with the object to uplift their status. The decision has been taken on the 8th December of 2023. I have challenged on the ground that while identifying the indigenous Muslim of Assam, the Muslim communities of Bodak Valley has been excluded. But this intention is very clear that when a certain groups being identified as indigenous Muslims, that is the other groups are being identified as immigrant Muslims. And when they have identified 5 subgroups of Muslims who are living in the Brahmaputra Valley, considering their historical background, Lordship will find that who are the 5 subgroups. These subgroups, the report in page number 19 of my petition.
Is your petition page?
Lordship,
Petitioner,
yes, Lordship.
your PIL is not paged. There's no pagination in your
It
PIL.
is not numbered.
Oh.
I am extremely sorry, Lordship. I sincerely apologize. It
Petitioner in person is direct to paginate the PIL. And list the matter again on. We'll have it on 22nd.
22nd of January. Lordship.
Item 3.
May it be lost, my lord. This is a PIL against the some serious, I should not say scam, my lord, the animals and other misconduct in the going on in the university, Rabindranath Tagore University in Hojai. I was the petitioner had been serving as my professor in Hojai College, which was upgraded to the level of university by an act of Assam Assembly in 2017. And in the matter of appointment, my lord, there is totally pick and choose and nepotism. A person, a Bengali department, advertisement is there, my lord, that it is reserved for OBC. A man from Bengal applies. He is not OBC here. He is domicile of Bengal, not domicile of Assam. The other candidates who are domiciles of Assam, leaving them, the person from Bengal was appointed. And he is not OBC here. As far as advertisement I have annexed. Secondly, my lord, in the case of deputy registrar also, my lord,
Is it service matter? Can there be a PIL in the service matter? Oh. Yes.
in the case of deputy registrar also, same thing happened. And in the control of examination, deputy control examination, my lord, a person who had criminal record for in Dispur College, molesting a girl student, was also appointed, my lord. And non-OBC persons, in the case of my lord, this Bengal department, this court, he had applied in the earlier in the Hojai, my lord, Lanka College. There on examination, he was found to be not OBC. They were rejected. His application rejected. He came to this court. This court observed that he is not OBC and he is not entitled. He went in a writ appeal. There also it was rejected, my lord. That person now is appointed in the Department of Bengali. So, my lord, and not only one series and financial scams, my lord, about 61 lakhs was guaranteed, my lord. That amount is nowhere. Another amount of 1 crore is for developmental liability of granted, there is nowhere. Well, this is only note. I am seeking for notice, my lord.
Anybody?
And in two cases, my lord, earlier individual cases, my lord, while you also was sitting in single bench, my lord, you also state the appointment and of the advertisement of two candidates in similar ground.
Here also, I am representing higher education department, also, not representing the Rabindranath Tagore University. Also. Otherwise, it is admitted fact that lordship, the persons who belonging to other state lordship cannot carry the lordship, the OBC certificate to the another state. As per Delhi Jal Board judgment and subsequently so many judgments there also.
Right.
And the fact is that whether PIL is maintainable or not, that issue lordship have to decide.
This is what
Other-
you're trying to
Otherwise, it is an admitted fact that lordship one person cannot carry the, but whether in the service method PIL is maintainable or not, that part lordship has to. Otherwise, I have no objection, lordship.
Heard Mr. R.B. Sharma. Then it's senior counsel, assisted by Mr.
Ardhar.
Ardha, counsel for the petition. So, issue notice. The issue of maintainability of this PIL is kept open. Petitioner to, Mr. A. Gogoi,
I am for 1, 2, and 6, lordship.
Learned Standing Council Higher Education. Appears for respondents 1, 2, and 6. Petitioner to take steps for service of notice on respondents 3, 4, 5, and 7.
by
registered.
within
post
3 days,
date
my lord.
within-
7 standing council is there of UGC.
Anyway, you take
Okay, I will take it. I will take.
within 1 week from today,
Yes.
at least after 4 weeks.
Notice the mission, my lord.
Yes.
How will I go?
Item 4 for implemented party.
May I please your lordship? Lordship, I have filed, my lord, 3875 for implement of necessary party in the proceeding, my lord. The State of Assam, AIDC, Assam Industrial Development Corporation, and Mr. Kuldeep Burma, liquidator of the Hindustan Paper Corporation. my lord.
On what grounds?
My lord, the company, my lord, Hindustan Paper Corporation went up, my lord, and as a result of which, my lord, the liquidator has been appointed. And my lord, now the government of Assam, my lord, has taken over the whole public enterprise that is Hindustan Paper Corporation.
The state of Assam Industries, I don't have any problem.
How about the other respondents?
Others, lordship, like,
It was appeared for respondent number 1, Hindustan Paper Corporation, my lord, but subsequently it is liquidated, my lord. And as per my lord order of the National Law Tribunal, my lord, a liquidator has been appointed. So my lord, liquidator is necessary party. And
but he's also been asked for, requested for being implemented.
Yes, my lord. Yes, my lord, I have implemented as respondent number 4, my lord.
Heard Mr.
T.U. Laskar, my lord.
T.U. Laskar will not counsel for the applicant. By this also heard Mr. A. Kalita. You are appealing for
Respondent number 1, my lord. Respondent number 1, my lord.
your good name, please?
T.S.K.
T.
S.K.
S.K. Learned counsel for the respondent number 1
I'm for respondent 2, lordship.
and Mr. A. Kalita. learned
Respondent number
counsel
2.
For the respondent number 2. Stop. By this application, the applicant is praying for impletion of the secretary to the government of Assam, Industries, Commerce and PE Department, Assam, within bracket, Roman 2, the Assam Industrial Development Corporation Limited, represented by the Managing Director, and within bracket, Roman 3, Shri Kuldeep Verma, liquidator of Hindustan Paper Corporation Limited, 46 BB Ganguly Road, Street, Unit 501, Kolkata 7000012. As party respondents 2, 3 and 4.
2, 3 and 4, my lord.
Party respondents 2, 3 and 4. In writ appeal number 268 of 2018. Stop. We have perused the course shown in the present application and we are satisfied. Accordingly, the
You already.
implement of the aforesaid 3 respondents in writ appeal number
Does it go?
268 of 2018 is allowed. In the writ appeal, we have the order bus today in IS1, so let you give the full address, huh? Be included as
Okay.
party respondents 2, 3 and 4 in the present appeal. Stop. Notice has to go, isn't it?
Notice has to go, lordship, for at least for the liquidator. The could respond.
All
not
the
for-
3 respondents will have, okay.
I'm representing respondent number 2, so that's,
Okay, you have represented
I'm.
Mr. A. Kalita, legal counsel, and this appearance on behalf of the newly implemented respondent number 2. Stop. As such, no formal steps are required. The appellant to take steps for service of notice on the respondents 3 and 4 by registered post 80 within 1 week
Lordship.
from today. List after 4 weeks. In the meantime, the appellant is directed to file an amended cost title.
Obliged, your lordship.
Item 5 for admission.
Look, in this case, an affidavit is being filed within the day, man. Can it be listed along with the affidavit? This is in reply to their rejoinder. On the subject of, my lord, Anganwadi establishment of Anganwadi centers.
What affidavit have you filed?
My lord, we filed a reply to her last rejoinder, my lord. That is being filed today, my lord. It is being filed within the day, my lord. So let the matter be mixed along with that.
I was also supposed to file an affidavit. I have filed today only. This morning I had filed the affidavit. I was also supposed to file one affidavit.
Additional affidavit.
Yes, Lordship, I had filed it.
Ms. D. Ghosh, learned counsel for the petitioner submits that she has filed an additional affidavit this morning. Mr. B.D. Goswami, you are appearing for?
I am for the state, my lord, but this affidavit is filed on behalf of respondent number 3.
You are the additional AG.
Yes, my lord.
Arunachal.
Yes, my lord.
The additional AG Arunachal Pradesh. Appearing for the respondent number
3, my lord.
submits that he has also filed a rejoinder affidavit. That he is filing rejoinder affidavit.
Within the day.
Within the course of it. Okay. Please stand to verify and place the same on record and list the matter one.
After the BU vacancy,
2nd February.
my lord.
Second.
Much older.
Deeply.
Item 6 and 7.
Thank you, Lordship. My lord, in item 7, my lord, the counter affidavit has been drafted. It has gone for vetting, my lord. I appear for the High Court. My lord.
When can you file it?
Lordship grants me 2 weeks' time.
Heard Mr. M.E. Mahmood.
Deeply obliged, Lordship.
MSS Shaman and his standing counsel Guwahati High Court submits that affidavit has been sent for vetting with regard to WPC number 102 of 2022. And first for 2 weeks time to file this. Praise allowed.
Lordship
Yes.
is obliged.
Item number 6, I am appearing for Transport Department. I have filed my
Please down after 2 weeks.
Obliged.
Both 6 and 7.
Yeah.
Item 8.
On behalf of the respondent number 4, I have prepared the affidavit and Lordship may give it 2 days time. By Friday, I'll file.
Why?
By Friday. I have already prepared the affidavit and send it for
Respondent number
4. my lord. The PWD, Chief Engineer, PWD road. I need 2 days time. By Friday, I can file.
heard Mr.
AI Qatar.
AI Qatar Learned Counsel for the petition. Mr. D. Nadlan, Senior Government Advocate, submits that he will be filing affidavit on behalf of respondent number 4 within a period of 1 week. Praise allowed. List after 2 weeks.
2 weeks, not.
Item 9.
May I please, your lordship? My lord, on last 3-4 occasions, my lord, and time has been sought for, and my lordship was kind enough to give them the time to file an affidavit, my lord. My lord, the matter relates no affidavit, my
We
lord.
have filed the affidavit. In fact, my lord, the learned senior counsel, Mr. M.K. Chaudhary, he was appearing earlier. My colleague has informed me that my clerk has contacted him. My lord. He has informed that he is no longer appearing in this case. Therefore, giving an undertaking, my lord, we have filed the affidavit and copies with us, my lord. Copies with us.
Then, my
We are
lord,
giving- on 5th of January, we have filed.
then, my lord, I am sorry for the statement I have made, my lord. It has not been, not within my knowledge, my lord.
What affidavit?
Affidavit in opposition by the respondent, my lord.
By respondent number?
It is by, my lord,
By 2, my lord. Respondent number 2.
It is on.
my
You
lord.
receive a copy?
My lord, just now I have received,
Yes,
my lord, been served, my lord. Lord, matter relates to, my lord, that the serious allegation as regards the IPSC anomalies, my lord. There is a one-man inquiry committee report by our honorable retired Judge B.K. Sharma that we want, my lord, that the action should be taken basing on that inquiry commission report as well as that, my lord, report should be made public, my lord. That too limited prayer, my lord, we have.
So you want to go through the affidavit? now?
Yes, my lord,
Yes.
go through, my lord. We'll go through, my lord, may fix a short date, my lord, next week, my lord, or
Mr.
immediately after the vacation, my lord.
Okay, on request made by Brian, then the council. Please, when do you want?
Lord, immediately after the vacation, around 23rd, my lord. Please take it.
We have fixed lot of matters on those days.
Right. Let it be on 29th.
My lord,
29.
Yeah.
My lord.
29.
oblige, my lord.
How late?
Item 10 to 12.
May please your lordship. My lord, this matter, three matters are identical in nature. This pertain to construction of roads under the Prime Minister Grammar Sadak Yojana. And my lord, the matter needs to be, my lord, taken up for hearing, otherwise it will be, my lord, infructuous. What happened, my lord, the contract was given to the present petitioners, appellants, my lord, and that was challenged. The ground was that, my lord, there was a clause in the NIT which says that beyond 10% variation of the price, it will be rejected. And therefore, my lord, we all submitted within 10% variation. And we are qualified and we are given the contracts. Thereafter, that was challenged, and eventually one of the honorable single judges held that that is not as per this standard bidding document. And he did not stop there, my lord, by setting aside the contract. The rest part of the contract was directed to be given to the, my lord, private respondent here. So issue is small, my lord. May I pray that the matter will be taken up for disposal,
Today.
my lord.
Yes, Google.
I leave it to your lordship.
All parties are here.
Yes, ma'am.
Only thing, my lord, that work has already been, my lord, started by the, my lord, private respondent.
It is already more than
Pursuant to the order passed by the, my lord, honorable division, single bench of this honorable court. We have already allotted.
And
he is continuing.
that's why the urgency, my.
David, I don't know if I can hear you.
My lord, after, my lord, immediately after reopening.
See, Mr. Chowdhury, I'm having some health issues today.
My lord, I will not trouble you.
That is the problem.
I'll only pray for short date, my lord,
Yeah.
for final disposal.
See, 18th and 19th, maybe this court will not be there.
No.
So,
23rd is a Tuesday, my lord. 23rd is a Tuesday. Can that be a day?
okay. List this matter on 23rd. January for admission hearing.
The lordship will kindly make an observation that, my lord, for final disposal of that
I
day.
said for admission hearing. Admission hearing.
And endeavor to dispose of, my lord.
An individual will meet the dispose of this with this appeals on the next written.
Obliged.
I'm sorry.
No, I am not troubled.
Item 13.
Make please, your lordship.
I'm the one. Thank you.
I please your lordship. I'm appearing on behalf of V. Mahanta. There are some personal problem on behalf of him. I pray to take adjournment.
Respondent 1 and 3.
1 and 3.
lordship.
Council of Architecture. Third K. Majumdar.
Lordship, I pray little bit urgency there, Lordship. I pray any day subject to convenience of this honorable court.
K. Majumdar, then the council for the appellants. Also heard H. Gupta, then that's CGC. For the response number 2.
2 months.
Stop it. On request made on behalf of P. Mahanda,
V. Mahanta.
Standing Council.
Standing council,
then
architect.
Standing Council, Council of Architecture. This the matter. When?
Lordship, subject to convenience. It may be after.
After being
Up to Bihu, many cases have been listed.
Can it be lordship on 23rd? Lordship will say admission hearing is just,
23rd, how many cases are listed?
then 25th lordship, please.
If we go to same thing, I think. 30, 30.
Item 29.
I am appearing on behalf of private and small. Advocate of the appellant is not present.
That medical admission matter, my lord, the petition, appellant was granted time to have instruction from his client whether he'd like to withdraw or my lord. Lordship has already expressed the mind that Lordship will dismiss the petition. my lord. Last two occasions, my lord, the time was sought for to have that inspection.
None appears for the appellant. Mr. B. Google and his standing counsel, Health Department appears for respondent,
My lord, for respondent one.
one. And Mr. A.K. Purkayastan and the counsel appears for the respondent. List the matter again after 2 weeks.
My lord, yes, my lord, only my lord 24th and 5th may not be a lecture night.
I'm not giving a date, I'll say, I'm just saying 2 weeks.
Item 30.
This is a matter regarding Milad Panchayat Milad, where the Milad appellant Milad was removed from the post Milad pursuant to a Milad confidence motion Milad.
Where's Handik?
Records were also called for.
Yes, records were called.
Yes, Milad called for records.
I apologize, my lord. My lord, I'm appearing on behalf of the senior standing counsel. Records were sent. My lord, on the
Take
last
on
occasion,
what?
records, yes, my lord. Records were called for. We have communicated with the chief executive officer. We have received some instructions, but he had provided certified copies of the records. He has not provided the original record.
He has to produce the original records.
My lord.
When this court asks for any records, it has to be produced in original.
My lord, in addition to that, my lord, the ballots paper will be required. My
So
lord,
what do you want?
my lord, some additional time may be granted after the BU vacation. My lord.
Same document and the counsel for the appellant. On request made on behalf of K. Konor, Leonard Senior Standing Counsel, PNRT Department, PNRT. Another?
My lord,
How much time?
my lord, after the BU vacation on
This, the matter again on 2nd February.
Element 25th Milad of this month Milad, because his term is also expiring Milad, otherwise on 6th of February Milad.
We'll have it on 29th
29th Milad. Milad.
to enable him to produce the records.
Obliged Milad. 32. Diploma.
In this case, Milord, I will have to file an additional affidavit, Milord, incorporating the subsequent developments. After filing the appeal, consequential order has been passed. That has been stayed by the direct single judge. The petition proceeding, my lord. I will incorporate those subsequent developments, my lord.
After filing the appeal,
Yes, my lord.
Mr. I.S. Cycle and the counsel for the appellant submits that subsequent developments have taken place after filing of the present writ appeal and prays for filing an additional affidavit incorporating the same. So, praise allowed. One,
1 week
how much time?
after BU, my lord.
After 2 weeks?
Up to 2 weeks, my lord. acknowledgement.
33,
But here, Malad, I pay for 3 weeks for a time. The rule has been challenged here, Malad. On behalf of the Chief Secretary, I'm here, respondent number 3. I'm appealing. I pay for 3 weeks.
My lord, they have taken so many days time, my lord, one after another date, my lord.
No,
My
the-
petitioners,
the-
what happened?
Chief Secretary has been implemented later on, Malad. Earlier, respondent number 1 and 2 were there. But since the rule has been challenged, now the Chief Secretary has been implemented. The matter has been taken up with the department, Malad, because the rule has been framed by the other department.
What happened?
I pay for 3 weeks time in respect of the rules. Otherwise, on facts, Malad, I have
Let
nothing.
them file affidavit, we have no objection, my lord, that they take time, that is also. My lord, but what happened, in the meantime, the education department, they are trying to, my lord, harass the petitioner by issuing the shockers notice one after another, my lord, that you have pursued the degree without taking the NOC. My lord, they have pursued the degree on Sunday, my lord, Sunday, without hampering the duties assigned to them as per their duty. They have done their duty, and on the Sunday they have pursued the course, my lord. For that, whether the authorities have the jurisdiction during the period of Sunday, my holiday, over the employee.
Okay, heard Mr. B. Progress to Learning Council for the petitioners. On request made by Mr. D. Nath, Leonard Senior Government Advocate Assam. 3 weeks further time is allowed to file counter affidavit. List after 3 weeks.
A date may be kindly given.
Give a date of 3 weeks.
5th of February.
Fifth. Okay. After 10 minutes.
Not.
Oh, Marshall, you're here?
My lord, if it is otherwise possible, my lord, Lordship kindly consider our prayer, because he is just to obtain instruction and appraise the court. So matter may be, my lord, taken up on 22nd, if it is otherwise convenient.
22nd, we fixed too many cases.
It is a matter of 5 minutes, my lord, you just appraise the court, whether instruction is received or not.
Have you received instructions?
My lord, that part, my lord, will make the argument, my lord. I have not yet.
Argument already over.
No. I name both argument.
Argument is
1
over.
second, Lordship will.
Okay, second.
item 34,
My point that, when I visit to the order, just inform my lord, it's refixed on.
Please, the Lordship, my lord.
No, 2nd of February.
Lordship, I have received the affidavit. I seek some time to file a reply, the affidavit.
I have filed my. I shall file my, I received the instruction.
Mr.
A. Fukan.
A. Fukan, Learning Council for the petitioner. How much time you have?
To the union's affidavit, I'll need 3 weeks, Your Lordship.
Press for 3 weeks time to file affidavit. To file rejoinder affidavit to the counter filed by the Union of India.
May I request if
Please.
it can be kept on the 19th, subject to convenience of Your Lordships.
February,
19th February.
list on 19th.
Deeply obliged.
item 35,
Well, this is an appeal under section 260A of the Income Tax Act, my lord. Against the order of the tribunal, the proposed substantial question of law, your lordship find as to page 25.
Page
25, my lord. Lord, in fact, the tribunal, after rejecting the appeal, my lord, granted us liberty to approach the CVT, and we approached the CVT after the CVT rejected it. Then we came up before this Honorable Court challenging the order of the tribunal. And in the condemnation petition, the lordship condoned the delay in filing the appeal only on the ground that the time was consumed by the CVT. Now the questions which have been stated to the appeal, my lord, the questions you also find at page 25, para 21. Four questions are there, my lord.
It's okay. I think it's okay. Yeah.
My lord, only thing, my lord, that the order passed by the learned, my lord, appellate tribunal, my lord, that has been complied by the SSC, my lord. So lordship may see the directions, my lord, at page, my lord, ITET order annexure 11, page 131, my lord. 131. My lord, the relevant portion at page 137, my lord. Paragraph 13, my lord. We therefore, under the given facts and circumstances of the case, are of the considered view are that since the SSC had filed belated return, the claim of deduction under section 80 IC of the Act cannot be entertained allowed as the SSC is directed to hit by provisions of section 80 AC of the Act. We thus fail to find any infirmity in the finding of the learned CIT appeal denying SSC's claim of deduction under section 80 IC of the Act. However, if deemed fit, the SSC can still approach the board for consideration of its case, and if the board finds merit in the reasons for genuine hardship of the SSC for filing the return belatedly, the case of the SSC may be considered sympathetically. If such permission is granted by the board, then the assessing officer can allow claim of deduction of the SSC under section 7 of the Act in accordance with law. Thereafter, my lord, their application, my lord, before the, my lord, board, my lord, that is page 145. Lord, I'm sorry, my lord, it's
Yes.
Lord, their application, my lord, at page 139, my lord. Annexure 12. Subject prayer in conformity with the order of the Income Tax Appellate Tribunal passed under section 7. And in fact, in their statement also, my lord, at page, my lord, 142, my lord, paragraph 8, my lord, they have stated that it was in compliance of the order passed by the Income Tax Appellate Tribunal. But since the SSC has complied with the order, my lord, and board has also passed the order, my lord, against the SSC, my lord, and that order was not challenged, my lord. Since at this stage, my lord, since that the order of the appellate tribunal they have complied with, whether this appeal is maintainable, my lord, that is the question.
There was no compliance of the order. That was liberty given to the SSC to approach the CBT. That is not the compliance of the order of the tribunal. If the liberty is granted, that you also can approach the CBT. And if I approach the CBT, that doesn't mean that I have accepted that order of the tribunal. The tribunal's order can always be challenged. And the CBT, my lord, only that you can also go there. And I approach there. And if I don't go there, my lord, then they will say that approach, you have been given the liberty, why you have not gone there? So if only going to CBT does not mean that the tribunal's order has become final. Well, how it can become final? And this is a statutory appeal against section 260A, under section 260A of the Act. That is in compliance with the liberty which was given by the tribunal, in compliance to that liberty.
You are appealing on behalf of all the respondents?
Lordship.
The substantial. Heard Dr. A. Salam, the senior counsel. Assisted by?
SJ Soikia.
S.A.?
SJ Soikia.
S.J. Cycle and the counsel for the appellant. Stop. Mr.
S. Chetia.
S. Chetia, and the standing counsel.
Lordship.
Income Tax Department. Appears for the respondents 1 and 2. Notice on respondents are complete. Para. After hearing the learned counsel for the parties, the following substantial questions of law are framed. Page 26. No, page 25.
Four questions, bro.
8A. Okay. Admit. This is the matter. When? After 4 weeks?
No, in the interim, my lord, the order of the tribunal may be stayed, otherwise they will start recovering, my lord.
Where's the order?
My lord, order you will also find You want to say?
Lordship will find the page, my lord. 131, my lord.
That is dated 17/10/2022. My lord.
Where's the date?
17/10/2022.
In the interim. The order of the tribunal dated 17/10/2022 shall remain suspended.
Like,
36.
Please, Your Lordship. Lordship, I appeared on behalf of Mr. B. Purukaista. In this case, additional affidavit has filed, Your Lordship, but it has not come with the record. So it may be come after vacation, my lord.
Okay, Miss, your good name, please?
M.U. Ahmed.
Mr. M.U. Ahmed, learned counsel appearing on behalf of Mr. B. Purkayastha,
Right.
learned counsel for the appellant. Submits that they have filed an additional affidavit. When?
After vacation, my
No, no, when did you file it?
day before yesterday, my
They filed an additional affidavit. Stop. Registry to verify and list its matter.
obliged.
Again on, register to verify and place the same on record, huh? List the matter again on 29th.
Obliged.
37.
Well, in this case, that's now I received the file, my lord. Can it be taken on Friday? I take
Friday? Friday will be some difficulty.
even Monday next.
next one.
Monday.
Some urgency is involved or what?
Urgency, my lord, interim order I prayed there was not granted to me, so I have come against that. So the issue is very simple. Both the private respondents are junior to me. They were fighting between themselves in respect of their seniority.
Monday is a holiday.
I'm sorry.
Bihu.
Yes, sir.
It's your.
Otherwise, the day after tomorrow also your lordship can take it. If it is otherwise not inconvenient to your lordship.
Some problem is there, that's why.
My lord, my lord. Then let it be let it be on 19th, my lord. 19th is the Friday. Because immediately on 18th, my lord.
19th also I'm not there. There may be no sitting on 9th. Have it on 22nd.
22nd. My lord.
What's his name? What's his name? What is it? Okay. Heard Mr. D. Majumdar, learned counsel for the appellant. On request made by Mr.
And then be told.
And then B. Chowdhury, learned counsel appealing for
I have a state of ownership.
State
learned
respondents.
government advocate.
I am
State
the
respondents.
additional advocate.
Additional AG.
Additional Advocate General appealing for the state of Arunachal Pradesh. List on 22nd.
Deep.
38 for orders.
Lordship, can you pass over for time in Lordship?
What? What?
The senior is on leave, Lordship.
Why is this coming up?
Lordship, actually, government side has filed a compliance order report. Against the compliance report, I have to file our affidavit in reply. They partly comply the order of the PIL, Lordship. Lordship may kindly see the page number 108 of our affidavit in reply.
So you want to file your affidavit?
Yes, Lordship.
Lordship, you file it.
Lordship, if I may submit, Lordship, their plea is that we have not complied with the order. We say that we have complied fully. No more compliances can be done. So some hearing will be required to dispose of this matter. At the same time, Lordship, the DC Kamrup Metro has been transferred and a new person has joined as DC. So if your Lordship is not satisfied with the compliance and is of the opinion that any further compliance is required, perhaps addition will be required of parties. So based on that, if they want to wait for the senior, it can be passed over for some other day or today, whatsoever the Lordship may deem.
No, let them file the affidavit and we'll see.
No, already I have filed affidavit, Lordship. Otherwise, Lordship grant 2 weeks time to file an implement petition to implement the newly incumbent.
That is fine. MS,
And they,
L, the learned counsel for the petitioner prays for 2 weeks' time to file an appropriate IA for implementation of office. List after 2 weeks.
Comply, Lordship.
39,
Lordship, this order of the honorable court has been complied with, Lordship, and I have filed an affidavit to that effect.
As per my instruction, my lord, they have wrongly calculated the, my lord, entitlement of the
That
petitioner.
Another issue, Lordship, there is a
The
mistake in calculation.
entry level pay scale has been given, but subsequent pay hikes that has not been given to the petitioner. The entry level pay scale is, my lord, 5,000 to 8,000. That has been given, but after completion of 5 years, it should have been 5,500 to 9,000. And on completion of 15 years, 6,500 to 10,500.
That will be a different subject matter.
But my lord, in the order, my lord, it was directed to pay the subsequent pay hikes also, my lord.
Lordship, I take my affidavit for a moment, Lordship. And
Where's your affidavit?
that was filed on
Page 56.
respondent number 4.
Yes,
But the respondent number 4, yes,
Mm.
Lordship.
Yes.
And my explanation, Lordship, at paragraph 4, there has been some adjustment, Lordship, since he was not there after his transfer.
Where's the order?
Order lawsuit filed at page 11 of the contempt petition, my lord. And relevant portion is page
No,
22.
order of compliance.
Order of compliance.
Lordship, I have given the calculation sheet and as well as Lordship at page 67 is the slip, Lordship.
I think there's substantial compliance. Hmm?
If your lordship peruses the calculation sheet at page 65, therefore your lordship will come to know that the subsequent pay hikes has not been given to the petitioner.
The net difference is shown at page 66 in the right-hand side column. There has been some deductions shown below. Ultimately, Lordship, net arrear 86,462 has been paid.
I'm not against the deduction, my lord. My case is that, my lord, subsequent pay hikes, which was directed to be paid by the civil court, that has not been given.
Have you filed an affidavit? If you're not satisfied with that, you'll have to file an reply affidavit.
I will file.
Otherwise,
Right.
what we have noticed is that they've substantially complied with the order.
I'll file, my lord.
It's up to you.
My lord.
Or you can agitate before the appropriate for. It's a new,
Lordship,
it'll
in
be a
my
new,
humble submission,
be a new course of action.
if there is any
My lord, lordship,
discrepancy in that calculation, that will be he can file a subsequent writ petition, but
Yes.
That liberty may be granted. That liberty may be granted.
well, that is always there with him. Lordship. He can always.
Yes, already the issue has been adjudicated by the Supreme Court, my lord, earlier in the earlier round of litigation. And already direction is there to pay the subsequent pay hikes also. That has not been given. So, my lord, without liberty, my lord, perhaps my lord, I will not be able to approach the Supreme Court again.
Lordship can give him the liberty. I do not have any objection to that. But
But I can and counsel for the petition. Also heard Mr. R.K. Dev Chaudhary, learned
Lordship, advocate.
learned counsel.
It's
40, respond number 4. Stop.
Lordship, please.
Respond number 4 is filed in affidavit. Wherein at para 4. It is stated as under. You quote para 4. So ISIKL and the counsel for the petitioner submits that the respondents are yet to, what is yet to be given to you?
My lord, the entry level pay scale has been given, but subsequent pay hikes on completion of
But
5 years
this-
service and 15 years service.
That the subsequent pay hikes after completion of 5 years
5
of
years
service
and 15 years.
and 15 years of service has not been paid to the petitioner till date. Stop. Para. On consideration of the submission made by the learned counsel for the petitioner, we are of the opinion that it will be a new course of action. And accordingly, petitioner is given liberty to approach the appropriate for agitating his legal rights. Stop. After considering the affidavit filed by the respondent number 4, we are of the considered opinion that the substantial complaints has been made by the respondents, and accordingly, a contempt petition is closed. With liberty to the petitioner to approach the appropriate forum, seeking
Subsequent pay hikes.
yes, if any further grievance subsists.
Deep level.
Item 40 and 41.
Please, Lordship, my lord, these two items were earlier listed in admission column, my lord, but how it is-
Why is this coming for orders?
we have checked the record, but no official notice regarding this listing in orders. But my lord, the matter pertains to a issue of termination of contractual service of the two petitioners, my lord, as computer assistance under DRDA.
Then we will list it for admission.
Yes, ma'am, for admission after Bihu vacation, my lord.
Yes. On request made by the parties, list this matter for admission after 2 weeks.
A date may be given, my lord, may appear for a date. my
On
lord.
First, February.
Obliged.
Obliged, madam. 42.
Please, Your Lordship. Lord, in this matter, there are around 330 private respondents. We had already taken steps for completing service on them. But service is not complete, is what I understand from the report, Your Lordship. We can wait one more round, Lord, and after that, maybe if required, we may have to carry out substituted service. Because even for the condonation of delay, we had to serve them through substituted mode.
Okay.
Support time.
Await service report on the unserved respondents and list the matter again on
19th February, subject to
19th of February.
obliged.
Item 43.
May it please your lordship. Mala, there are two interlocutory applications. One 2464 is for substituted service and 2288 is for delay condonation. my lord, I have taken substituted service and I filed affidavit. I think, my lord, all other private respondents has appeared to their respective counsels. So now the consideration is for the delay condonation application.
My lord, I am for appearing for respondents, my lord, 9/14/18 like that, my lord. But the thing is that I have not received the copy, I have not gone through this, my lord. So at least. The continuation application? Yeah, my lord.
My lord, then, my lord, I have to serve.
A short date. 1 minute, 1 minute. You are appealing for which respondents? My lord, respondent number 9. How many respondents are there?
Yeah, around 100, my lord.
108 like.
108. I've gone through substituted service and all have appeared, I think.
All respondents are represented?
Yes, but we have not received a copy.
No, that's fine.
But I'm appearing for 10 of the response. That's right, number 17, 19, 26, 27, 30, 33, 34, 35, 49, 67, 67, 77.
No, are all the respondents represented, private respondents? You are appearing for? No, I'm appearing for 9, 14, 18, 29, 37, 44, 60, 75, 77, 81. This
You are
is
appealing?
going to be very difficult. How do you?
He is appearing for respondents.
Just a minute.
Go there.
We are having.
Because the understanding to petrol public. Appealing for only 5.
Here is also one side, no respondent is appealing.
Okay. In the IA 228 of 2023. Heard Mr. T.K. Roger Chowdhury and the counsel for the applicants. Peruse the affidavit filed by the applicant showing service of notice on the respondent, on the private respondents by paper publication. So, on consideration of the same, we are satisfied. And accordingly, the affidavit is accepted. Notice on respondents shall be deemed to be complete. I is disposed of.
Lordship, I'm appearing for Karbi Anglong Autonomous Council. Lordship, in delay condemnation, Lordship, we would like to file objection.
No, where's the continuation application?
2288. IA 2288.
This is the continuation application.
Yes, my lord. And 2464 is for substituted service.
Okay, then don't say like that. Don't say I is disposed. Huh? No, shall be deemed to be complete.
In 2464.
Now it will be a problem. Who appears for Karbi Anglong?
Lordship, I'm appearing for Karbi Anglong Autonomous.
Mr.
R.S. Ronghang.
I.S. Ronghang. You give your name.
Yes. R.S. Ronghang.
Write it down.
Yes.
Then the standing counsel, Karbi Anglong, appears for the respondents. 2.
I think up to 225, my lord.
225. Correct.
Yes, yes.
Who is appearing for the education department? K. Das, then the standing counsel, education department, appears for respondent number 1. Up to that, so and so for respondents 2 to 5. Now, who appears for respondent 6? Private respondent number 6.
I am a respondent. 12, 13, 15, 21, 30, 43, 50, 53.
13. Mr. Your good name, please.
Mohammed Bakkar Ali. Last one.
M. Ali.
My lord, it is shown in the cause list, my lord.
Private response. We are appearing for some of them from 6 to 108.
Where is 6? I can't see 6.
Mr. Gora, you are appearing for respondent number 6. No, not we are appearing for other private respondents, 17, 18, 26, 14 of them.
Okay, but who is appearing for respondent number 6?
I think government can take care of it.
How can the government take care of the phone numbers? Why by name?
Well, I think from 6 is not government, well, they are private respondents now, they are working. I was sorry in making the submission.
No, they pursuant to the selection process, they have been appointed.
They are appointed, and so they are
They
the,
are present designation is this.
this one.
Who is appearing for R6?
No.
They were, the service was given by paper publication from R6 to 108.
The appears all are not represented.
All, so let us wait for some days from 6, because paper publication was from respondent number 6 to 108.
Oh.
Let us wait for some days. Man.
Okay, you cancel the order. But Mr. P.K. Roy Chowdhury, then is also for that. There will be affidavit filed by the applicant showing service of knowledge on the private respondents by paper publication. Stop. I will. Oh, no. List the matter again on. When do you want?
Malad.
After 2 weeks?
Malad.
List the matter again after 2 weeks. Yeah. We're not recording your appearance.
My lord. Well, in the meantime, they may I could serve the copies also, my lord. No, we'll serve.
Meantime, you serve copies.
Well. Hello,
Learned counsel for petitioner shall furnish copy of the present IA to the learned counsels appearing for some of the private receiving.
hello,
Item 44.
Your Lordship, the matter first came up on the 1st of December. Time was sought for the respondents to file their objections. I understand that they'll probably agree to the delay of 171 days. That is my submission.
Let it be condoned.
K. Das. Any objection? Heard Mr. M. Sharma, let me call to the applicant. So, also heard Mr. N. Das, let me government advocate. For the respondents 1 and 4. NMS K. Das, Learned Standing Council School Education Department. For the respondents 2, 3 and 5. Stop. By this application, the applicant is praying for continuation of 171 days delay in filing the connected writ appeal. Stop. But we have perused the cost shown in the present application and we are satisfied. And actually, accordingly, the delay of 171 days in filing the connected writ appeal is allowed. Yes, disposed. Registry is directed to numbered writ appeal and list the matter in its usual course.
I'm grateful, Your Lordship.
45.
It is Lordship. Lordship, an appeal has been preferred by IA today is for condonation of delay, my lord.
How many days?
153 days, my lord.
Notice may go, Lordship. Yes.
You want to file your objection?
Yes, Lordship, you may file an objection.
Mr. Jay Singh, then counsel for the applicant. Mr. A. Kalita,
For respondent number 2 and 3, Your Lord.
then standing counsel,
Yes, standing counsel number 2 and 3.
Industries Department, appearing for respondents 2 and 3. Praise for how much time?
2 weeks time, Lordship.
2 weeks time to file objections.
If any, Lordship, you just.
If so advised. This after 2 weeks.
Obliged. Obliged.
Item 46.
May it please your lordship.
In this case, there was a delay has been condoned. And today has the matter, I am praying for stay of the impugned judgment, lordship. The basic case here is, lordship, page 48. There is an office memorandum of 1st June 2015 regarding compassionate appointment. And one clause was put to challenge. Clause number 1, which lordship will find at page 48, second paragraph from bottom in the appeal memo, lordship.
In the appeal.
In the appeal, lordship.
Page number?
Page number 48. May I read it, lordship, this paragraph? Clause number 1, only one dependent family member of a government servant appointed on regular basis, excluding the one working on daily wage, or casual or apprentice, or ad hoc or contract or re-employment basis, who die in harness or become incapacitated due to accident suffered while on duty, and is eligible to opt for invalid pension under relevant provisions of service rules, pension code, and or who is missing is eligible for making application for compassionate appointment, provided in each case the government servant has balance of minimum 3 years of service. So this proviso is put to challenge. From earlier, we have that scheme, this condition was not there. In 2015, we incorporated this condition, and this was put to challenge on the ground of discrimination. This office memorandum is not an offshoot of any statutory rules. It is the policy decision of the government. Government can give compassionate appointment, government may not give also. In 2017, we had brought a press memorandum by which any person who died in harness, his family members will be entitled to get full salary of the incumbent who passed away. So policy is changing from time to time. So this policy was invalid for about 2 years' time. And during that time, the writ petitioners applied and they were rejected on this ground. Very few. But those posts were already filled up by that during that course of time, 2015, 2016, 2017. From 17, there is no scope of application. Whoever dies, his family will get full salary, including pension, including increment. So nobody is going to apply under the new policy, which is in force today. So the learned single judge, these writ petitions were filed sometime in 2018, 2019. And very recently, the impugned order was passed, which lordship will find at page 136. And page 139, it is the starting part of the judgment, 31/2023. So the policy which was in force from 2015 to 2017 was finally, the Honorable Court was pleased to set aside that clause number 1, on the ground of discrimination. We are challenging this because on several counts. The case is very simple. First, the subsequent policy is in force. Nobody prayed for any effect of this policy with a retrospective effect. All the posts which were, because only 5% in a department in a year are considered for compassionate appointment. There may be 10 persons, only 1 or 2 persons get in a department. So all those posts were already filled up. Today, if we have to consider the incumbents of 2015 or 2016, whose parents or whose father or mother have died at that point of time, we have to give posts of the current year. For these different persons are eligible now. That is number 1. There is no such post as of now. We do not fill up any, we do not have any compassionate appointment post nowadays because nobody is replaced. The whole family gets a full salary as if the person is alive. So that is one part. Number 2, lordship, the most important part is that if we have to implement this policy, this order, then we have to reconstitute the state level committee, etc., we have to do. And also
there are series of Supreme Court judgments, series of High Court judgments, that a compassionate appointment has to be given within a period of 2 years. Thereafter, there is no meaning of compassionate appointment. So in that view of the matter, Lordship have to examine this. I am praying for admitting this writ appeal at this stage and be pleased to stay the application of this impugned order at this stage. We'll argue on this point, why we have incorporated that 3 years criteria. 3 years criteria was, there's a justifiable ground, Lordship. The justification is very clear. A person who is at the age of retirement, Lordship, his whole family is entitled for full pension. So he qualifies the qualifying period under the pension rules, Rule 31. So therefore, whether he is alive or he is not alive does not make or may impact adversely the family financially, Lordship. So the whole concept is to give them, we want to give at that point of time, not today, in 2015-16, we want to give preference to those families whose earning member was young, the family is young, maybe their childs are kids, but a person who is at the time of retirement, Lordship, he has already have the children's grown up, or the family is readily entitled for getting the pension. A person who dies at 35 years or 31 years, or maybe within 3 or 4 years of service, and a person who has already served for 30 years in service, there's a huge difference. So there is reasonableness in this. I am not using the word discrimination, but the differentiation. So what the learned single judge has finally found out, Lordship, in paragraph 7 in I'm just yes. Page 155, paragraph 17. This aspect of the matter can be seen from the affidavit filed by the state, wherein it has been mentioned that strictly on humanitarian ground and to save the surviving family of the deceased government servant from destitution, an exception is carved out in spite of Article 16, and that is how the state government provides for appointment on compassionate grounds. Therefore, the object sought to be achieved is for the purpose of tidying out the family over the sudden crisis on account of the death of the sole breadwinner. Now, coming to the affidavit as well as the contentions made by the learned senior government advocate, there is no material for which the classification has been thereby depriving the family members of those government officials who die in harness having less than 3 years in service. Taking into account that is for the state to satisfy the twin conditions which have been mentioned herein above, and the state respondents herein have failed to show any intelligible differentia on the basis of which the classification has been made, thereby grouping those government officials who die in harness having less than 3 years balance in service from others, and further that the said differentia have a rational nexus with the object sought to be achieved. This court is of the opinion that the classification so made, thereby depriving the benefits of the OM to the family members of the government officials who die in harness having less than 3 years, to be illegal, arbitrary, and discriminatory, and accordingly, clause 1 of the OM to the effect that the dependent of the government officials who die in harness having less than 3 years of service is being deprived is accordingly struck down and violation of Article 14 of the Constitution and accordingly unconstitutional. My first submission is that this OM is no more in force since 2017. In fact, this was an academic exercise which was done. When the law is not in force, when the provisions of this OM is not in force, after 9 years, and on top of that, compassionate appointment, there is a strict bar that under no circumstances a person can be accommodated on the ground of compassionate appointment once the person overcomes the sadness or whatever destitution the family faces at the time of death or in the family is over within a period of 2 years. So I'll place all these judgments, Lordship. In that view of the matter, this judgment is not applicable as on death. And on top of that, all the posts were filled up way back in 2015, 16, and 17. if the challenge was made in 2015 itself or in 16 itself, Lordship, the issue would have been alive. But in 2023 or 2024, Lordship, this is just an academic exercise. And moreover, it is a policy decision under a welfare scheme. No right accrues for compassionate appointment. It is not an offspring or offshoot from any statutory rules. Service rule don't provide for any compassionate appointment. It is always under an administrative fiat or an order under Article 162. Hmm? Repetition. Ground clear. So we have filed a separate petition for staying the impugned judgment, Lordship.
Have you implemented this court's order?
Sorry, Lordship.
Have you implemented this order?
No, Lordship, we have not.
You were given 30 days.
30 days. The applications were started coming. Immediately we took the decision because it is not covering only one department. It was covering all the departments. So we have to create posts. This is a very long exercise, Lordship. We came before this honorable court because all the administrative departments are affected by this order. And therefore, Lordship on the last occasion directed us to give a notice to the other party through Dusty Service. We have done that also. They refused to accept it to that effect. We have filed the affidavit also.
In the appeal.
In the appeal, Lordship.
Where
In
is
the
that?
stay petition.
Stay petition.
In the condonation, he received it.
Hmm.
Condonation was delayed. And now in the IA, where we have filed for stay petition, Lordship was pleased to direct us to take Dusty Service. We have taken, and Lordship will kindly see that affidavit of filed on 9/1. That means yesterday we filed it. Paragraph 3. 2 and 3, paragraph 2. The Honorable Court via order dated 5/1/2024 allowed the applicants to take steps for service of notice upon OP 1 by Dusty notice. In compliance of the aforesaid order dated, the applicants have taken steps of service of notice through Dusty and obtained copy of the notice dated 6/1/2024, duly acknowledged by the registry of the Honorable Court. Thereafter, the aforesaid Dusty notice was sent to the office of the Deputy Commissioner Golaghat to serve Dusty upon the OP number 1. Accordingly, Ashish Paul and Lokhikanto Phukon, Jarikarak of the office of DC Golaghat, went to deliver the notice dated 6/1/2024 to the residents of OP number 1. But the OP number 1, Sri Deepak Gogoi, refused to receive the notice, and since the Gaon Pradhan was not present there, they obtained the signature and seal of the headmaster of number 1 Khumtai Model LP School and ward members as witness to the fact of refusal to acceptance of notice by the OP number 1. The aforesaid Jarikaraks of the office of the Deputy Commissioner Golaghat have given report on the backside of the notice, which is said returned after service to the Honorable Court. 4. The deponent backside the earlier person said the application of paying condonation delay, it was all triggered. In preferring the appeal, the applicants have already taken steps of service upon OP number 1 by Dusty, and Opposite has duly accepted the same. An affidavit as regards service of notice by Dusty in IA for condonation of delay was filed by the applicant on 18/7/2023, and the same is available on record of the Honorable Court. Therefore, the OP number 1 is well aware about the pendency of the instant proceeding before the court.
There's no
আমি থেকে appeal তো fail করছি।
Delay কিমান আছিলে? Delay?
Within this
Hmm?
notice on the opposite party can be deemed to be complete. I can, this
Delay?
Huh? Affidavit.
Our delay was for only 28 days, Lordship.
1 minute.
IA 1126.
You don't have a copy of this affidavit? Mr. Nath? You have not given a copy of this, you have not filed 2 copies of your affidavit showing dusty service?
So we have filed. We have given 2 copies. But today in the morning we have called.
In this one?
No, today in the morning we have called for. Yes, it has been called for and the from the registry will directly.
Where is the affidavit? One affidavit is here. No. This is interlocutory application. That is an affidavit. IA 3787 3898. We found the wrong copies. We sent the wrong copies. This is an IA. This is an affidavit.
In the IA only.
Yeah.
In IA 3787 affidavit is filed.
No, that's fine.
No.
They should furnish 2 copies of this. Your affidavit, one has come, one has not come. This is the problem now. It was ordered in the morning.
Well, appeared.
Extra copy that you can we submit 1 extra copy for Lordship's perusal?
Yeah. we can do that.
The earlier documents he received personally. When we served the IA for the condonation of delay, the Deepak Gogoi himself received it. That was on 9th of July. Page 12. In IA 1126.
You can have filed at least a translated copy.
The translated copy is also there, Lordship, next page. In the first.
No, there's no translated copy.
Oh, okay.
Of page 65 and 66.
65. The first part is in English, second part, Lordship, yes.
Can you read Assamese? You supply because see, I cannot.
Lordship.
My brother also, he has difficulty reading it.
And if Lordship is pleased to look at the earlier one, just for Lordship's consideration, IA 1126. There it was translated also, where Deepak Gogoi himself received the first delay condonation. That means it is to his knowledge,
No, no,
everything.
that is there.
That is there.
But you want to be very sure about this. You file translated copies.
Let it come tomorrow, we'll file a translated copy also for Lordship's perusal.
Can you do it by tomorrow?
We'll do it tomorrow. Only this part, the below part of 2 pages.
2 pages. Mr. Dean, we'll record Mr. Nath's name then.
My appearance may be recorded, Lordship.
Okay, but Mr. D. Cycle and Advocate General Assam, assisted by Mr. D. Nath, Leonard, Senior Government Advocate for the applicants. Stop. Vara. Mr. D. Nath, Leonard, Senior Government Advocate, shall furnish translated copies of page 66, page 65 and 66 of the affidavit. When did you file this affidavit?
Yesterday.
Of the affidavit filed on 9th January 2024.
To an additional affidavit, Lordship. We'll file an additional affidavit where they translate.
By way of an additional affidavit. List on tomorrow,
Tomorrow, Lord.
11th.
Highly obliged.
Item 47.
Lord, this IA is for consideration of delay, Lord. 283 days delay is there, Lord, in preferring the appeal. At this stage, Lordship may kindly issue notice, Lord, and allow me to take steps by Dusty.
But D. Nath, Leonard, Senior Government Advocate for the applicants. Issue notice. You want to take steps on all?
Yeah, no, on one, Lord, OP1.
The applicants are permitted to take steps for service of notice on the opposite party number 1 by Dusty Service to the registry of this court within a period of 1 week from the day thereafter. Applicant shall file an affidavit to that effect. List after 4 weeks.
Next is same. The next item is also similar.
Same order.
Item 49.
Please, your lordships. My lord will take up the IA 78. Page number 17, my lords, to start off with. Page 17 was the order passed by your lordships in the writ petition, wherein notices were issued. The standing counsel for the respondent bank entered appearance, accepted notice, and prayed for time for filing affidavit. On that given day, there was a query falling from your lordships whether there was any sale notice issued in respect of the property. To that, the reply that came from the standing counsel of the bank was that there was no sale notice. Page number 18, my lord will kindly take up page number 18. My lord will see this is the extract from a paper publication from the Times of India dated 17th December 2023, wherein the sale notice has been published. The sale notice is down below. Your lordship will kindly see at page number 18 itself. This is the extract from the paper publication that has been published in the Times of India. Now, your lordship will kindly see.
Just a minute.
My lord.
Page number?
This is page number 18, my lord. This is
IA 78.
yes, my lord. Just to reprise, page number 17 is the order passed by this honorable court in the main writ petition on 15/12/2023. Page number 18 is the sale notice published in the Times of India on 17th of December. And the notice, if your lordship sees from the paper publication, there's a small date notified in that notice. Your lordship will kindly see 14/12/2023 in the notice from the paper publication, if your lordship sees at page 18. From the notice, if in the right-hand corner, if your lordships notice the date, that is 14/12/2023. Now, my lord, this very notice has been served upon the petitioners, the applicants, by speed post as well. That notice we have annexed at page 19. Page 19 kindly, my lord. My lord will again see the date of the notice is 14/12/2023 at the top right-hand corner. Now, in this notice, my lord, surprisingly, if your lordship just comes down below in a box that is provided, and if your lordship kindly takes up Roman number 6 in that box, publication of sale notice in newspapers, 17/12/2023. And this notice is dated 14/12/2023. This is the surreptitious ploy by the bank. My lord, there are certain other things that I beg to draw your lordship's kind attention to. My lord will take up page number 21 for a while. This is the envelope wherein this notice was served upon the applicants. Your lordships will take note of the speed post number, the consignment number that is there. This is from the envelope straight away. And then my lord will kindly see at page 22, this is the tracking of the consignment. And here it clearly, it reflects the consignment was booked on 27/12, and it on the next page, page 23, it was delivered on 28/12. So my lords will kindly take into note the fact that it is projected that this sale notice is dated 14/12/2023, a day before the passing of the order by this honorable court, wherein notice was issued, and my friend appearing for the respondent bank had sought time for filing affidavit on a query put by this honorable court whether sale notice was issued. There was a response, there was a reply that there is no sale notice as such. But now it is sought to be projected that on 14/12/2023, a sale notice has been issued, and it has been published in on 17/12/2023, and it has been served upon the applicants by post as well. And my lord, here from the modus that is quite apparent. This notice was dated 14/12. It was dispatched on 27/12. It has been delivered on 28/12. And in this notice on or dated 14/12, there is a mention of a paper publication dated 17/12. So this is foretelling at its very best. There cannot be foretelling of publication of this notice in the concerned newspapers. They have mentioned even the names of the newspapers. The publication date, that is 17/12, but the notice is of 14/12. My lord, case of fraud, my lord, I have been able to satisfy your lordship's prima facie on the day of motion hearing, on the basis of which, my lord, notices were issued. They were given time to file affidavit. 18th is the date fixed. In between, these are the things going on. I was constrained to file this IA and bring it to the notice of your lordships. I pray for stay of this sale notice, my lord, because this is out and out abuse of the process of law. Had this, my lord, this been the development, had this been the fact that there was an issuance of sale notice on 14/12, this could have been apprised before this honorable court on 15/12 when this matter was taken up for motion hearing. On that day, on a specific query put by this honorable court, the reply was that there is as such, there is no sale notice. In the writ petition, we have only challenged the possession notice on the ground of fraud. And on being prima facie satisfied, your lordships were pleased to issue notices. Now, in between, my lord, this is the development that has taken place. I pray this matter will again come up on 18th. But my lord, before that, this my lord, the intervention of this honorable court in respect of this sale notice, my lord, is highly warranted, my lord.
Have you served notice?
Yes, yes, they have received the notice that is there on record. And today, my lord, understandably, they are perhaps not appearing for reasons, my lord, because the standing council had on the last occasion given the reply to this honorable court that there was no sale notice. And now this is the position. And my lord, insofar as the merit of the case is concerned on that, I had already made my submissions on the last occasion. Your lordships, my lord, want me to again replace those facts, my lord. This is a case out and out. It's a case of fraud. I have implemented the bank authorities as well as the borrower. We four petitioners and petitioners stroke applicants, we are the sons and daughters of a lady who is now no more. She was fraudulently arrayed as a guarantor to the loan. Her title deed was taken by the borrower, implemented as respondent number 3 and submitted before the bank, and an equitable mortgage was projected to have been carried, created. The deceased lady had filed a suit for cancellation of those deeds. During the pendency of the suit, she died, she passed away. On getting to know about all this, her sons and daughters, they have filed a criminal case before the appropriate forum, before the appropriate court of law. In that case, there has been an order passed where, my lord, the learned magistrate had asked for a police investigation. The police investigation is still pending. So, pendency of the investigation by police in regard to the alleged fraud, these are the activities sought to be carried out by the respondent bank. They are so desperate to get the property disposed of even before the investigation reaches its logical conclusion as regards fraud. This, my lord, raises doubts regarding the modus operandi. So my humble prayer at this stage, my lord, this matter is, as it is fixed on 18th. Your lordship will stay the sale notice. Let the bank, even on 18th, my lord, they have the opportunity to respond to this as well as to the main writ petition. And what made them to get this sale notice published on 17/12, just 2 days after the passing of the order by this honorable court.
Finding, can you pass the order? No. Yeah, still. Or I'll pass it. What, Mr.
D. Chakrabarti, ma'am.
D. Chakrabarti, learned counsel for the applicant. None appears for the respondent bank, or none appears for the Punjab National Bank. Despite service of notice. Stop. According, stop. List the matter again on, when is it?
18th is a matter. The 18th is fixed. The main writ petition is fixed on 18th of January.
18 January. In the entry, the sale notice dated
14/12/2023.
12/2023.
Published in Times of India dated 17th December.
Published in the Times of India dated 17 December 2023. Shall remain suspended.
Deeply obliged.
I have heard the other side, Lordship, yesterday. They have not whispered a single thing about the 1st October's. They only relied upon 2nd. So my whole case is that the 2nd October's withdrawal letter is not a withdrawal letter as per the statute. And 1st is actually the correct version, but it was submitted at a delayed or belated stage. That time period is already over. And they have argued on the point of substantial compliance regarding the 2nd October's withdrawal. 2nd September's line, October. Yes, yeah, 2nd September's, no, October's, Lordship. October. Now, we have, if we look at the scheme of the act. কোনকেইটা section আছিলে?
Section 72.
72, but before going to 72, I would like to place section 14.
Section 14.
There are different functionaries in a panchayat. There are Gaon Panchayat, Jilla Parishad, and Ancholik Panchayat. So, when it is the case of Gaon Panchayat, section 14 covers. Section 14 says resignation and removal of president and vice president. Have you also got it? The president or vice president of Gaon Panchayat may resign his office by writing under his hand address to the deputy commissioner and to the president of the Gaon Panchayat as the case may be. Every resignation under subsection 1 shall take effect on the expiry of 15 days from the date of its receipt by the authority, unless within this period of 15 days he withdraws such resignation by writing under his hand address to the deputy commissioner in case of precedent. So when a Gaon Panchayat president resigns and if he wants to withdraw within 15 days, he will have to write it to the deputy commissioner. So the deputy commissioner is the head of the district and there are several villages, Gaon Panchayats. So in that situation, the legislature deemed it fit that the deputy commissioner is the authority who can take a call regarding the withdrawal. It is not a very casually worded thing that the letter has to be addressed to the government in case of the president of the Jilla Parishad. If there is a deliberation on this, had these provisions being challenged, we would have come with the whole exercise, how it was formulated, what was the legislative intention, everything. But as it is not in challenge, we have to read it as it is. And there is no prayer for reading down the section also. Forget about setting aside. Reading down the section is also not provided. What they are trying to say that substantial compliance now. So my submission is that in case of the president of a Gaon Panchayat, it has to be addressed to the deputy commissioner. In case of Jilla Parishad, in case of Ancholik Panchayat, Lordship will kindly come to page 30, section 42. Resignation or removal of the president and vice president of Ancholik Panchayat. Here, a member holding the office of president of the Ancholik Panchayat may resign his office at any time by writing under his own hand address to the deputy commissioner of the concerned district, and the vice president may resign his office at any time by writing under his hand address to the president of the Ancholik Panchayat, and in absence of the president to the deputy commissioner of the concerned district. Every president and vice president of Ancholik Panchayat shall vacate office if he ceases to be a member of the Ancholik Panchayat. In this case, there is no scope of withdrawal also. So for president and vice president of Ancholik Panchayat, there is no scope of that 15 days time required for vacation of the office. Now coming to 72. So three different situations are contemplated under the scheme of the Panchayat Act. It is not in a very casual or mechanical manner that the 72 wordings are incorporated or mentioned. In 72, it is said, a member holding the office of president of the Jilla Parishad may resign his office at any time by writing and send it to the government through the deputy commissioner, and the office shall become vacant on expiry of the 15th day from the date of such resignation, unless within the said period of 15 days he withdraws such resignation by writing and send it to the government. The legislature could have used the word deputy commissioner here. They have not. In case of Gaon Panchayat, they have used the word deputy commissioner. So the overall scheme, we have to look into it. So there is no question of mandatory or directory. It is abundantly clear. It is a mandatory provision. There is no scope of substantial compliance here. Here it requires full compliance, total compliance. In this regard, I would like to place few judgments. But before placing of the judgment, my submission is that they have said that we have written some letters and waived the right.
Ours is the operation.
Yes.
Nineteen 1981 SCC page 403. Sarifuddin versus Abdul Ghani loan. In paragraph 9. The difference between a mandatory rule and a directory rule is that while the former must be strictly observed, in the case of the latter, substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain broad propositions which can be deduced from several decisions of courts regarding the rules of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall, which laying down a duty, is not conclusive on the question whether it is mandatory or directory provision. In order to find out the provision of law in question in order to find out the true character of the legislation, the court has to ascertain the object which the provision of law in question has to subserve and its design and the context in which it is enacted. If the object of a law is to be defeated by non-compliance with it, it has to be regarded as mandatory. But when a provision of law relates to the performance of any public duty and the invalidation of any act done in disregard of that provision causes serious prejudice to that for whose benefit it is enacted, and at the same time who have no control over the performance of the duty, such provisions should be treated as directory. Where, however, a provision of law prescribes that a certain act has to be done in a particular manner by a person in order to acquire a right. Here, the acquiring of the right is that withdrawal of his resignation. So where, however, a provision of law prescribes a certain act has to be done in a particular manner by a person in order to acquire a right and is coupled with another provision which confers an immunity on another when such act is not done in that manner, the former has to be regarded as a mandatory one. So in our case, for withdrawal, he will have to submit his application before the competent authority. There are different competent authority under the Panchayat Act. The competent authority in case of withdrawal of resignation for the post of president in Jilla Parishad is clearly defined as the government. In case of the other situations, that is regarding the Gaon Panchayat president, it is a deputy commissioner. So a procedural rule ordinarily should not be construed as mandatory if the defect in the act is done in pursuance of it can be cured by permitting appropriate rectification to be carried out at the subsequent stage, unless by accordance with such permission to rectify the error later, another rule will be contravened. Whenever a statute prescribes that a particular act is to be done in a particular manner and also lays down that failure to comply with that said requirement leads to a specific consequence, it would be difficult to hold that the requirement is not mandatory and the specified consequence should not follow. Our consequence is very clear. If you don't withdraw it within 15 days, your resignation letter becomes final and the office becomes vacant. That is the direct meaning of the provision. So a particular mode is preferred and that mode has to be fully complied with. There is no scope of any substantial compliance in this case. I am reading another judgment, Lordship, 2009 6 SCC. 2009 6 SCC, page 735. Ramdin Moria versus State of Uttar Pradesh. Here, if I have to seek transfer, I have to submit my application before the director. That is a mandatory condition the Honorable Supreme Court held. There are other situations which are not considered to be mandatory. Here, the relevant paragraphs is at paragraph 38. Paragraph 38. Rule 4.6 speaks of manner and the method of making an application for the purpose of transfer. In order to appreciate the submissions of the learned senior counsel, sub-rule 6 of rule 6 of the rules requires to be extracted. The same is under the transfer application for single mutual transfer from one college to the other shall be submitted to the director, higher education, through the management legally constituted and approved by the university along with written consent of both the two management. The director, higher education shall submit his recommendation to the government within 1 month from the date of receipt of the application. The government shall take decision either on the basis of the recommendation of the director or on its own. So director has a specific role here. Rule 4.6 of the rules provides the procedure for making an application by a teacher desirous of transfer from one college to another college against the available post for which salary is paid from the salary payment account. Under the rule, the transfer application for single or mutual transfer from one college to the other college requires to be submitted through the legally constituted management along with the written consent of both the management to the director of higher education. Skipping the next part, I am coming to paragraph 43 and 42. Having examined the rules, the principle evolved by the court, let us now examine whether non-compliance of one of the facets of Rule 4.6 of the rules would be fatal to the application filed by Dr. Madhu Tendon. To answer this issue, it is necessary to find out whether the rule is directory or mandatory. If it is mandatory, then it is settled rule of interpretation. It must be strictly construed and followed, and an act done in breach thereof will be invalid. But if it is directory, the act will be valid, although the non-compliance may give rise to some other penalty if provided by the statute. It is often said that a mandatory enactment must be obeyed or fulfilled exactly, but a directory provision's non-compliance of it has been held in many cases as not affecting the validity of the act done in breach thereof. Rule 4.4, Rule 4 sub-rule 6 of the rules is in 4 parts. There are: number 1, the transfer application for the single mutual transfer shall be submitted to the director, higher education. 2, it shall be submitted through the management along with the written consent of both the management. 3, the director, higher education shall submit his recommendation to the government within 1 month. The government shall 4, the government shall take decision either on the basis of the recommendation of the director on its own. Paragraph 45. Filing of the application before the director is a must for transfer for reasons under the rules. It is he who is expected to consider the application to find out whether the application is eligible for such transfer and whether the application has obtained consent or no objection from both the management, namely from the management where he or she is working or to the college where he or she wants to be transferred, and if the requirement in this behalf is not complied with, the director may reject the application at the threshold itself. Further, the rule specifically provides that the application for the purpose of Rules 4 must be filed only before him, and no other authority of the state government in this part of the rule requires to be considered mandatory. This part of the rule requires to be considered mandatory. In our case, who is going to take the call that the resignation is withdrawn? It is the government. The deputy commissioner has no role there. So the application should go to the government and it should be addressed to the government. The government will not take a call unless it is addressed to them under the scheme of things. I want to file a writ petition, Lordship. If I write the application, let us take a writ petition, Lordship. We have annexed the writ petition. Page 24. Page 24. It is addressed to the Honorable Justice Sudhanshu Dhulia so-and-so, Honorable Chief Justice of Guwahati High Court, and Lordships, other companion judges of the court. Suppose I want to file a writ petition and wrongly I went to the district court. I addressed to the district judge and it was forwarded to the High Court. Will that application be acceptable to this Honorable Court? That application for withdrawal was addressed to the Deputy Commissioner of that particular district, Karimganj. Same was also uploaded in the website of the Panchayat and Rural Development Department. Whether the government, when it was not addressed to it, the government can act under the scheme of the rules. So if I want to file a writ petition in the Honorable High Court, I will have to address it to the Honorable Chief Justice of Guwahati High Court and other judges here. I cannot write it to the district court or district judge of Kamrup district so that the registry of the district court will send it here and this Honorable Court will consider. Same is the scheme. So when a competent authority is prescribed, it is designated. That prescribed and designated authority must receive the application so that they can take the call. Just like in Uttar Pradesh, the director for transfer, whether it is single transfer or mutual transfer, the director is the person who is supposed to receive the application and nobody else. And that is considered to be mandatory by the Honorable Supreme Court. Same principle is applicable in our case. Under the scheme, there are different competent authorities under the Panchayat Act of 1994. Under different schemes, and in one case, in case of Anchalik Panchayat, there is no scope of withdrawal also. If they are unhappy with any of the provisions, they have to challenge it. But writing a letter to the Deputy Commissioner will not suffice the scheme of things as contemplated under the 1994 Panchayat Act, more specifically Section 74. In 1979, it is regularly relied in tender matters, but one paragraph is very important. The Dayanand Sethi's case, Airport Authority. Otherwise, the government officials will violate everything whenever it is favorable to their persons. They will rule according to their own whims and fancies. That is why precisely these rules are mentioned. A particular scheme is given. In 1979, 3 SCC, page 489. Ramanna Dayaram City versus International Airport Authority of India.
Yes.
Yes, Lordship. Now, there can be no doubt that what paragraph 1 of the notice prescribed was a condition of eligibility.
You're listing from which part?
Paragraph 10, Lordship. I read paragraph 10 only. Although it was in reference to a tender matter, but in this paragraph, they spoke about administrative law. Paragraph 10. Now, there can be no doubt that what paragraph 1 of the notice prescribed was a condition of eligibility, which was required to be satisfied by every person submitting a tender. The condition of eligibility was that the person submitting a tender must be conducting or running a registered class 2 hotel or restaurant, and he must have at least 5 years experience as such. And if he did not satisfy these conditions of eligibility, his tender would not be eligible for consideration. This was the standard or norm of eligibility laid down by the respondent 1. And since the respondent 4 did not satisfy this standard or norm, it was not competent to respondent 1 to entertain the tender. It is well settled rule of administrative. It is a well settled rule of administrative law that an executive authority must be rigorously held to the standard by which it professes its action to be just, and it must scrupulously observe those standards on the pain of invalidation of an act in violation of them. One line is enough, Lordship. May I repeat it? It is well settled rule of administrative law that an executive authority must be rigorously held to the standard by which it professes its action to be just, and it must scrupulously observe those standards on pain of invalidation of an act in violation of them. This rule was enunciated by Justice Frankfurter in so-and-so, where the learned judge said, an executive agency must be rigorously held to the standards by which it professes its action to be just. Accordingly, if dismissal from employment is based on a definite procedure, even though generous beyond the requirements that bind such agency, the procedure must be scrupulously observed. This judicially evolved rule of administrative law is now firmly established, and if I may add, rightly so. He that takes the procedural world sword by perish with the sword. He that takes the procedural sword shall perish with the sword. Suppose that application is given to us. The deputy commissioner received, and he acted upon it by violating the norms. The private respondent would have raised the same question here. It is not a withdrawal as per the scheme of things. Reverse way I'm arguing now, Lordship. How we would have defended as a state? We have set norms. And these norms for the officers are mandatory. Sometimes the Honorable Court decides and finds and observes that some norms are directory. But as an officer, this constitutional court can do that. But the officers are bound by what is there in black and white. We cannot change the officer, the person who is sitting at this court or who is sitting at the district level office, the deputy commissioner or his other officers, Lordship. They cannot play with the sentences in the statute. And when more so when the language is abundantly clear. There is no vagueness, no ambiguity. May I read further? So in that situation, whatever standards we set, we have to follow in the realm of administrative law. The deputy commissioner and the principal secretary is under administrative law, Lordship. Not specifically under election law here. Election law is more rigid. This court accepted the rule as valid and applicable in India in A.S. Ahluwalia, and in subsequent decision given in Sukhdev versus Bhagat Ram, Matthew quoted that the above referred observations of Justice Frankfurter with approval. It may be noted that this rule, though supportable also as an emanation from Article 14, does not rest merely on that article. It has an independent existence apart from Article 14. It is a rule of administrative law which has been judicially evolved as a check against exercise of arbitrary power by the executive authority. Suppose we have accepted it, Lordship, that would have been arbitrary exercise of power on our part. Because the Deputy Commissioner is not entrusted with that power of taking a call on a withdrawal application in case of a precedent of a Jilla Parishad. That would have been beyond his jurisdiction, he will be acting, and it will be an arbitrary exercise of power. Totally illegal. If we turn to the judgment of Justice Frankfurter and examine it, we find that he has not sought to draw support from the rule from the equality clause of the United States Constitution, but evolved it purely on a rule of administrative law. Even in England, the recent trend in administrative law is that direction, as it is evident from what is stated at page so-and-so of Wade's Administrative Law, 4th edition. There is no reason why we should hesitate to adopt this rule as a part of our continually expanding administrative law. Today, with tremendous expansion of welfare resources and social service functions, we come under social service function, increasing control of material and economic resources and large-scale assumption of industrial and commercial activities by the state, the power of the executive government to affect the lives of the people is steadily growing. The attainment of socio-economic justice being a conscious end of state policy, there is a vast and inevitable increase in the frequency with which ordinary citizens come into relationship of direct encounters with state power holders. This rendered it necessary to structure and restrict the power of the executive government so as to prevent its arbitrary application or exercise. Whatever be the concept of the rule of law, whether it be meaning given by Dicey in the law of the Constitution, or the definition given by Hayek in Road to Serfdom and Constitutional of Liberty, or the expression set forth in Harry Jones in his The Rule of Law and the Welfare State, there is a pointed out by Matthew in his article, The Welfare State, the Rule of Law and the Natural Justice in Democracy, Equality and Freedom. Substantial agreement in juristic thoughts that great purposes of the rule of law notion is the protection of the individual against arbitrary exercise of power wherever it is found. It is indeed unthinkable that in a democracy governed by the rule of law, the executive government or any of its officers should possess arbitrary power over the interest of the individuals. Every action of the executive government must be informed with reason and should be free from arbitrariness. That is the very essence of the rule of law and its bare minimal requirement. And to the application of this principle, it makes no difference whether the exercise of the power involves affection of some rights or denial of some privileges. So when a particular scheme is there, he will have to abide by it, whether by abiding of those principles can deny some advantage to some other individuals. But for that, the officer cannot act arbitrarily in favor of somebody. No, এইটোতো আছে কেইবাটাও adjustment আছে। Before going to the next judgment, two arguments I did not make yesterday, but it is very clear that they have resorted to suppression of material facts. I was expecting some response from them on which date the 1st October's letter was sent or submitted, but there was not a single whisper in their arguments or submissions, Lordship. That means they are hiding certain things from this Honorable Court. Whether the learned single judge considered the 1st October's letter or not, that is a different story. But they have to come with complete facts. They cannot suppress any material facts before this Honorable Court. They must come with clean hands. So when we said we received it on 8th, they immediately said we have submitted. Sorry, they have said we have sent. Initially in the writ petition, they said they have submitted. And when we said, yes, they have submitted on 8th, then they have taken a different course saying that we have sent it the 1st October's later. But when it was sent, that is very crucial. Till now, Lordship, they are not coming up with that answer. But our record says it very clearly. On 8th, they went to the office and submitted. We have the dispatch number. So their intention is not pure. When they come before a court of equity, Lordship, they must disclose all material facts. Whether the judgment will come in their favor or not, that is not material. But they should be honest to the court, which in the instant case, they are not honest. They have hidden the most critical point. And they themselves has written that writing to the government is most important. I placed it yesterday. Once more, Lordship, I'd like to refresh it. Page 32 of the writ appeal. I'm repeating, but Lordship, it is very essential for the purpose of my continuation of the present submission. Page 32. The second paragraph. It is respectfully submitted that the petitioner submitted his withdrawal letter on 1/10/2021 before the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department, and on 2/10/2021 again submitted a communication of his withdrawal of the resignation to the Deputy Commissioner for information. The second part is also incorrect, first part is also incorrect. That the aforesaid provision provides for submission of the application for withdrawal to the government only. So they have realized it, that it is the government before whom they have to submit. So their whole argument that substantial compliance is enough is not supported by this pleading. If they had said that we have submitted the letter on 2nd, the email, as well as the WhatsApp message, and that is sufficient. In that case, they can argue and take the plea of substantial compliance doctrine. But in the instant case, they are still harping that from the pleadings, of course, not verbally, that 1st October's letter is a correct form because it is addressed to the government, which they themselves has said the aforesaid provision provides for submission of application for withdrawal to the government only. So they know it very well, that it has to be submitted to the government. And they are not justifying that the second is correct. They are not arguing that. But what they are arguing, that before 4th, the 2nd October's letter was before the Deputy Commissioner. Whether it is Sunday or whether it is Gandhi Jayanti, that is immaterial in our case, Lordship. That is not our case. What we have said that the email, the hard copy, we received it on 4th. But we are not justifying it, that it is delayed. The delay actually happened on 8th, when the 1st October's letter was submitted before the Principal Secretary at Dispur. That 4 days time is the delay, not 4th. Whether it is 4th or 3rd, absolutely the general clauses will not be applicable in the instant case. We are not on that. If the 2nd October's withdrawal letter is a correct version, it has the statutory backing, then they are true. It was submitted well within time. But if it is not the correct version, the correct mode of withdrawal, then the 1st October's letter will come. Then Lordship will have to consider whether it was timely submitted or not. So may I continue at 2 o'clock, Lordship?
Next matter, I'm there, so I'm good.
Which next matter?
No, next matter, different.
Okay. Then we'll fix a date again. The other cases we are fixing on 23rd. 24th will be. On request met on behalf of NSB Buyan and PP. List on 24th.
I'll convey him.
24th January, huh?
Lordship. We have prepared the written argument. We can
Lordship.
hand it over.
You can
Lordship.
submit it.
Not. I'll hand it over.
However, in this matter, earlier, amicus curiae has been elevated, Lordship. Mr. Justice Kashif Goswami was appearing.
But you,
A Niyog, Lordship.
eh?
A Niyog.
Leonard, you're the amicus curiae now.
No, Lordship, the Mr. Justice Kashif Goswami was earlier appointed as a amicus.
Okay. Leonard counsel for the appellant. I'll just select.
Lordship.
Also had MS S. Jahan and PP for the respondents. Written arguments have been submitted. Judgment is reserved.
Lordship.
I'll hand it over to the court master.
Yeah.
Lordship.
Okay.
May it please your lordship. So my next citation would be 2009, volume 9 SCC, page 92. Paragraph 22 and 24. Vijay Narayan Khate and others versus State of Maharashtra. It is also regarding interpretation of rule and statute. Paragraph 22. In our opinion, when the language of the statute is plain and clear, then the literal meaning, then the literal rule of interpretation has to be applied, and there is ordinarily no scope for consideration of equity, public interest, or seeking the intention of the legislature. It is only when the language of the statute is not clear or ambiguous, or there is some conflict, etc., or the plain language leads to some absurdity, that one can depart from the literal rule of interpretation. A perusal of the proviso to Rule 6 shows that the language of the proviso is clear. Hence, the literal rule of interpretation must be applied to it. When there is a conflict between the law and equity, it is the law which must prevail. As such, the Latin maximum dura lex, which means that law is heard, but it is the law. So, in our case also, the language is very clear and there is no ambiguity or vagueness in the language of rule section 71(1). It is very clearly said that the application has to be written and to be given to the government.
71 or 72?
72, sorry. 72, subsection 1. Yes. Resignation or removal of the president and vice president. One says, a member holding the office of president of the Jilla Parishad may resign his office at any time by writing and shall send it to the government through the deputy commissioner. So when it is the resignation, he will have to route it through the deputy commissioner. And I'm skipping the vice president part. And the office shall become vacant on the expiry of 15 days from the date of such resignation. So here, Lordship will now, in the first part, they have used the word may. And now here, in the second part, when the office will become vacant, the word shall has been used. The office shall become vacant on the expiry of 15 days from the date of such resignation, unless within the said period of 15 days, he withdraws his resignation by writing and send it to the government. So it has to be written to the government and it has to be sent to the government within 15 days, not to the deputy commissioner. In respect of the president. In the other case, the other provision regarding the Gaon Panchayat President Section 14, it is very clearly written, Lordship, it has to be addressed to the Deputy Commissioner in case of withdrawal. So there is a scheme of things. And in case of Jilla Parishad President, there is no scope of withdrawal. Once you submit, that is the end of the story. There is no case of vacancy. The vacancy starts at the very point, forthwith. But here in these two situations, Section 17 and Section 14 in Gaon Panchayat President's case and in case of the President of the Jilla Parishad Lordship, there is a scope of 14 days, 15 days, when the resignation letter will become effective. So there is no ambiguity. Unless within the said period of 15 days, he withdraws such resignation by writing and send it to the government in respect of the President, or to the President in case of the Vice President, as the case may be. So paragraph 22 says, when the rule and the law is very clearly mentioned in the statute book, Lordship, the literal rule of interpretation has to be applied, not the other principles of interpretation of statute. Law may be heard, but it is the law. It has to be followed. Paragraph 24, in our opinion, there can be no estoppel against a statute. In our opinion, there can be no estoppel against a statute since the statute is very clear. The period of limitation provided in clause 2 of proviso to section 6 of the Act has to be followed. And the concession of the council have no effect, already stated. The proviso is mandatory in nature and must operate in its full rigor. So this is one judgment I am relying. There is another. There are a series of judgments, but I will rely only 2 or 3 on this line. 2011, 1 SCC, page 236. It's a full bench judgment of the Supreme Court. Commissioner of Central Excise versus Harichand Sri Gopal and others. It is in relation to exemption notification. In that situation, the Honorable Court was pleased to lay down the principles regarding the strict construction and substantial compliance. So paragraph 29. Although it is in the context of a fiscal thing, but general principles were laid down here. In our case also an exemption has been sought. How? He has tendered his resignation, but he wants an exemption by withdrawal. So once he has accepted, he is actually supposed to give, once he has resigned, it is the end of his chapter in the Panchayat Lordship. But here there is a scope for taking exemption also, that within 15 days you can revoke it also or withdraw it also. So may I place it, paragraph 29. The law is well settled that a person who claims exemption or concession has to establish that he is entitled to that exemption or concession. A provision providing for exemptions, concession, or exception, as the case may be, has to be construed strictly, with certain exceptions depending upon the settings on which the provisions has been placed in the statute and the object and the purpose to be achieved. If exemption is available on complying on certain conditions, the conditions have to be complied with. The mandatory requirement of those conditions must be obeyed or fulfilled exactly, though at times some latitude can be shown if there is a failure to comply with some requirements which are directory in nature. The non-compliance of such of which would not affect the essence of the or the substance of the notification granting exemption. I am not on the second part because my case is that he has to submit the application to the government. So that is a mandatory condition. I already produced the Uttar Pradesh case. When it has to be submitted to a particular competent authority, designated authority, there can be no substitute for that. So in that view of the matter, that part of the provision of the statute is mandatory in nature. The other part is regarding the time limit. That is also mandatory in nature. That within 15 days, not beyond 15 days. Now coming to paragraph 31. Of course, some of the provisions of an exemption notification may be directory in nature and some are mandatory in nature. A distinction between the provisions of a statute, which are of substantive character and were built in with certain specific objectives of policy on the one hand, and those which are merely procedural and technical in their nature on the other, must be clearly distinguished. In Tisco Limited's case, this court held that the principle as regard construction of an exemption notification are no longer res integra, where the eligibility clause in relation to an exemption notification is given strict meaning, wherefore the notification has to be interpreted in terms of its language. Once an assessee satisfies the eligibility criteria, an exemption clause therein may be construed literally. An eligibility criteria, therefore, deserves a strict construction, although construction of a condition thereof may be given a liberal meaning if the same is directory in nature. But in our statute, there is no such leniency shown. Now, what is substantial compliance? That part also I am placing from this judgment, paragraph 32. Doctrine of substantial compliance and intended to. The doctrine of substantial compliance is a judicial invention, equitable in nature, designed to avoid hardship in cases where a party does all that can reasonably be expected of it, but failed or faulted in some minor or inconsequential aspect, which can be described as the essence or the substance of the requirement. Like the concept of reasonableness, the acceptance or otherwise of a plea of substantial compliance depend upon the facts and circumstances of each case and the purpose and object to be achieved and the context of the prerequisites which are essential to achieve the object and purpose of the rule or the regulation. Such defense cannot be pleaded if a clear statutory prerequisites which effectuates the object and the purpose of the statute has not been met. This line clearly clarifies the situation. So this kind of substantial compliance defense cannot be taken when the statute clearly defines a particular action has to be taken to get the benefit. So may I read it once more? This last line. Like the concept of reasonableness, the acceptance or otherwise of a plea of substantial compliance depend upon the facts and circumstances of each case and the purpose and object to be achieved and the context of prerequisites which are essential to achieve the object and purpose of the rule or regulation. Such a defense cannot be pleaded if a clear statutory prerequisites which effectuates the objects and the purpose of the statute has not been met. Certainly, it means that the court should determine whether the statute has been followed sufficiently so as to carry out the intent for which the statute was enacted and not a mirror image type of strict compliance. Substantial compliance means actual compliance in respect of the substance essential to every reasonable objective of the statute, and the court should determine whether the statute has been followed sufficiently so as to carry out the intent of the statute and accomplish a reasonable objective for which it was passed. Paragraph 34 now. The test of determining the applicability of the substantial compliance doctrine has been subjected to myriad of cases, and quite often the critical question to be examined is whether the requirement relates to the substance or essence of the statute. If so, strict adherence to those requirements is a precondition to give effect to that doctrine. On the other hand, if the requirement of the procedural or directory in that they are not of essence of the thing to be done, but are given with a view of to orderly conduct of business, that may be fulfilled by substantial, if not strict compliance. In other words, a mere attempted compliance may not be sufficient, but actual compliance with those factors which are considered as essential. So the ratio which we can cull out from this lordship is that certain procedural things, there can be some leniency. But when a competent authority or designated authority is indicated and mentioned in the statute, who is entrusted to take a call on the issue of withdrawal of resignation, that particular authority cannot be substituted. That will be rewriting the statute. When the statute says the government has to take a call directly from the person who wants to withdraw, that authority can never be entrusted to the deputy commissioner. The deputy commissioner is not empowered to take a call on withdrawal. Had it been the case of the Gaon Panchayat president, he is authorized under the scheme of the statute of 1994. But for the purpose of withdrawal in case of president of a Jilla Parishad, he has absolutely no role regarding the withdrawal. Even while submitting the resignation, it is routed through the deputy commissioner. But when the withdrawal application is given, lordship, it has to be directly submitted to the government. The deputy commissioner's office has no role at all. So whether therefore the WhatsApp message to the deputy commissioner or the email to the deputy commissioner has nothing to do. And the email to the government, by addressing the letter to the deputy commissioner, the government cannot act on that mail. It has to come to the government. It has to be addressed. I have given the example of the writ petition. When it is addressed to the Honorable Chief Justice, then only this Honorable Court will open the door of 226. That way, when the statute says that the government will take a call on the withdrawal part, it has to go to the government. It has to be addressed to the government. And therefore, the language very clearly said, it has to be written to the government. 72. Last two lines of section 72. Unless within the said period of 15 days, he withdraws such resignation by writing and, or is not the word here, and by writing and send it to government. So it has to be written to the government. It has to be submitted to the government. There is no other option. That is why it is mandatory in nature. The competent authority is the government who can take a call whether the withdrawals can be accepted or rejected. So that the consequential action, whether the office is vacant or not, that call the government will have to take. This is one case. Then lordship, 2007. Yeah. Yes. The petition. 2005 to SCC page 271.
$2005.
2005, volume 2, Supreme Court cases, page 271. Paragraph 14. No, paragraph 13, 14, 15, 3 paragraphs. The interpretive function of the court is to discover the true legislative intent. It is a right that in interpreting a statute, the court must, if the words are clear, plain, unambiguous, and reasonably susceptible to only one meaning, give to the words that meaning, irrespective of the consequences. Those words must be expounded in their natural and ordinary sense. When the language is plain and unambiguous and admits of only one meaning, no question of construction of statute arises, for the act speaks for itself. courts are not concerned with the policy involved or that the results are injurious or otherwise, which may follow from from giving effect to the language used. If the words used are capable of one construction only, then it would not be open to the court to adopt any other hypothetical construction on the ground that such construction is more consistent with the alleged subject and policy of the Act. In considering whether there is ambiguity, the court must look at the statute as a whole and consider the appropriateness of the meaning in a particular context, avoiding absurdity and inconsistencies or unreasonableness which may render the statute unconstitutional. It is equally well settled that in interpreting a statute, effort should be made to give effect to each and every word used by the legislature. So in our case, when I am emphasizing on the word deputy commissioner as well as government, the word has a specific meaning. The deputy commissioner cannot take the shoes of the government. I will place the Assam Rules of Executive Business also, Rule 11 and 12 for that purpose. So it is equally well said the interpreting statute, effort should be made to give effect to each and every word used by the legislature. The courts always presume that the legislature inserted every part thereof for a purpose, and the legislative intention is that every part of the statute should have an effect. A construction which attributes redundancy to the legislature will not be accepted except for compelling reasons such as obvious drafting errors. Paragraph 15. It is well settled that literal interpretation should be given to a statute if the same does not lead to an absurdity. 16, 17 basically all are on the same line, paragraphs. Rule of Executive Business. Assam Rule of Executive Business. When we say government, Deputy Commissioner is not included there. It is a part of this service manual. It starts from 208 if we are holding the same book. No, I think it's a different book.
Assam Rules of Executive Business.
Yes, 1968. Rule 11. All orders or instruments made or executed by or on behalf of the government of Assam shall be expressed to be made or executed in the name of the governor. 12. Every order or instrument of the government of the state shall be expressed to be made in the name of the governor and shall be signed either by the secretary, an additional secretary, a special secretary, a joint secretary, a deputy secretary, under secretary, or such other officers as may be specially empowered in that behalf, and such signature shall be deemed to be proper authentication of such order or instrument. So the government is doing all the exercise in the name of the governor, and these are the officials who can represent the governor in government affairs. Unless somebody is specifically empowered. Now, recently, the government has empowered the deputy commissioner for a specific purpose in the revenue sector regarding land transfer and etc. Earlier, all the documents has to be signed by the commissioner and secretary or the secretaries in the revenue department. That specific power has been given to the deputy commissioner. But for running the panchayat, to represent the government at the panchayat level, that power has not been given till date. That is why, suppression, please. Read for a second. And they know it very well. Therefore, that is why their 1st October's letter is addressed to the principal secretary in the appeal. Page 44 and page 39. It is well known to the writ petitioner. They made a mistake and they have to now face the consequence for that. Page 39, the first resignation letter, I'm sorry, Lordship, the withdrawal letter. Page 41. Page 44 and page 45. Page 44 and 45. So page 44, dated 1/10/2021, Ashish Nath, President Karimganj Jilla Parishad, he wrote to the Principal Secretary, Government of Assam, Panchayat and Rural Development Department. He has inserted this word 1/10/2021 when we do not know, but it was submitted to the department on 8th of October after 8 days. Next page, Lordship will kindly see the another withdrawal letter. Same gentleman, he wrote to the Deputy Commissioner Karimganj. Had it been written to the Principal Secretary, Panchayat and Rural Development Department, that would have been sufficient. Because this was emailed to the Deputy Commissioner's office and also to the email address of the Panchayat and Rural Development Department. That would have been suffice. But addressing it to the Deputy Commissioner Karimganj in his letter, which actually received on time within the 15 days period. This through the email it was received, and also on the WhatsApp also it was received on 3rd and 4th, whatever date. I agree to that. But this letter 110, which was correctly drafted, addressed to the proper competent authority, designated authority, which they have manipulated later on. I'm using this harsh word, but they are also not coming up with an explanation till now. They are avoiding that part. What exactly was the event which led them to prepare this document with a date inserted on 1st October 2021 and annexed it in the writ proceedings? It is a different thing that the learned single judge did not give importance and took much emphasis on this. It was not properly considered also. But till now, they are having no answer on which date it was either sent or it was either submitted. There is no answer, clear answer till this moment. And for that purpose, Lordship, they are trying to mislead this honorable court. Again, I am using a harsh word. They have suppressed the fact which is most critical and most crucial in the instant case, on which date they have actually sent it. The law says it has to be sent, not submitted. So we are giving them a leeway. Even if it was posted on 1st October to the Postal Department office or through a courier or through any other mode of, that would have been sufficient to comply with the statutory provisions. But they have not done it and they have not disclosed it, although they are repeatedly in their replies, reply to the private respondent's affidavit, reply to the government's affidavit, that we have sent it and that is substantial compliance. This is what their argument is. But they are not indicating the date. If they come up with the date, either they have no case at all, which in all probability is the correct position. If they had a proper date, then they would have disclosed so that they can take benefit of that date. So for that purpose, Lordship, I am relying upon another Supreme Court judgment, one very small paragraph, 2007-6 SCC, page 120. Arunima Borua versus Union of India. Paragraph 12.
Not taking note.
Paragraph 12. It is tried law that so as to enable the court to refuse to exercise its discretionary jurisdiction, suppression must be of material fact. What would be a material fact? Suppression whereof would disentitle the appellant to obtain a discretionary relief would depend upon the facts and circumstances of each case. Material fact would mean material for the purpose of determination of the lease. The logical corollary whereof would be that whether the same was material for grant or denial of the relief. If the fact suppressed is not material for determination of the lease between the parties, the court may not refuse to exercise the discretionary jurisdiction. It is also tried that a person invoking the discretionary jurisdiction of the court cannot be allowed to approach it with a pair of dirty hands. Even if the said dirt is removed and the hands become clean, whether the relief would still be denied is the question. Paragraph 14. In Halsbury law, etc., he who seeks equity must do equity. Next page, 1305. He who comes with equity must come with clean hands. These are the basic principles. Now, he is not disclosing the date, whether it is a material fact or not. That is the question. When we are saying that 15 days is the maximum time limit, and when we are saying that 8 October was not the date, it was 4 days beyond the limited period. In their reply, they could have, when they have said that we have sent it, although in the repetition they have said we have submitted it. In our reply, we have said they have submitted it on 8th of October. Then they have changed their standard saying that we have sent it on time. They are not telling the date and time, on which date or time they have sent it. So that is suppression of material fact, which is vital to decide this list. In that view of the matter, Lordship, my humble submission is that they have not come before this court of equity with clean hands, and therefore they are not entitled for any relief. That is my humble submission. I am highly obliged for giving me a patient hearing. In that view of the matter, Lordship, this writ petition, this writ appeal is liable to be allowed and setting aside the learned single judge's order, because learned single judge's order is erroneous for the simple reason that there is no discussion on 110's withdrawal order, which is in the right format. Second one, 210/2021's withdrawal order was addressed to the Deputy Commissioner, which is not envisaged by the statute. And we have given substantial proof before this honorable court, which is not denied by them, with adequate materials, that we received the first October's letter on 8th of October. This is my humble submission. Deeply obliged.
Just one clarification with regards to 110 letter, my lord. In page 29 of the my lord writ appeal, it is specifically stated that the 110 letter was submitted before the my lord commissioner, before the principal secretary to the government on 110/2021. Again, in our affidavit, page, my lord, reply to the affidavit, page 132, regarding clarification. We have not suppressed anything, my lord, before this honorable court, my lord. Page 132. Page 132, Roman paragraphs 5.
1 minute.
Roman paragraphs 5, that the deponent reiterates that he had submitted his withdrawal letter dated 110/2021, 2021 it should be, on 110/2021 itself before the Principal Secretary PNRD, and vehemently denies the suggestion that the same was a backdated letter submitted only on 8/10/2021. Secondly, my lord, this, to substantiate that this letter was submitted on 110,
because my learned senior friend has said, my lord, this letter was received on 8th, my lord. This is not the correct position. Lordship, kindly see page 44. The first writ petition was submitted on 7th of October, my lord. 7th of October. Affidavit page 38.
Huh?
Affidavit page 38. Page 38.
Yeah.
Page 38. This affidavit was signed on 7th of October, 7/10/2021. And in this writ petition, my lord, the 110 letter was annexed as a copy of the, my lord, that I have submitted before the, my lord, principal secretary.
No, there's no signature, no date, nothing here.
My lord, this is the service copy upon the, my lord, in the record it will show, my lord. This was
This
filed
is
on,
record.
yes, my lord, original, my lord, writ petition which was filed, my lord. Lordship, kindly see on 8/10 order was passed. In the original writ petition, my lord, this is a part of this annexer was annexed from the service copy. Perhaps this was not dated.
So how do we,
From the
original
original record,
because this is a pertinent issue.
yes, my lord. Lordship, kindly
If
see,
you have shown this affidavit on 7,
yes,
then obviously
yes, my lord. Lordship, kindly see page 88.
we have to get the records.
Yes, more for it. Lordship, page 88. Record of the writ petition, page 88, my lord. Page 89, my lord, page 88 is the, my lord, WPC 5512/2021. Next page, page 89 is the order. In the second paragraph, it was referred. Second paragraph on 8/10/2021. Second paragraph. 1/10/2021 was referred to on 8/10. This is part of record, and this writ petition was filed on 7th. It is not a case there. It was received by the government on 8/10. On 8/10, an order was passed by this honorable court, referring to this order, this letter. This writ petition was filed on 7th, moved on 8th, order was passed on 8th, and the principal secretary was directed to produce the record with regards to submission of the application on 1/10, fixing 28/10/2021 as the next date. By this time, the principal secretary passed an order, my lord, allowing the vice president to hold the charge and to maintain status quo is there, my lord. Status quo order was there on 8/10. In violation of that, principal secretary has passed an order on 11, my lord. Next page.
We will have to see the records of the governance.
Records of the writ petition, original writ petition. Yes. Yes.
Okay.
Not.
Records are here with petition.
I think records can be requisitioned, man.
I'll produce the record. Cases like this. On 7th, they have filed a writ petition. In the writ petition, they have annexed the same document, the 10th October, this 1st October's later. 8th, the matter was taken up. That day, they went and submitted it. But it was with their hand. It is not that we produced it
How
on
they know
7th.
about the fact that it is
No, we filed the affidavit much later.
We have stated specifically that, my lord. And on second, my lord, we have also submitted a copy regarding, my lord, the address to the deputy commissioner, but it was submitted to the government, my lord, through website, my lord. How they can deny it, my lord?
There is no reference of
Already-
1st October's letter in 2nd of October's email.
Why it is
There is
required, my
no
lord?
reference.
There is no requirement of such, my lord, reference, my lord.
And where is the proof? There is an acknowledgement. Where is the acknowledgement? If suppose, let us assume they had submitted on 1st of October. Where is the receipt?
For that, my lord, the honorable single judge has not relied upon this copy of letter dated 110. We also, yeah.
Acknowledgement has to be given. That is why there is no proof.
They have.
Now, how can you say that you got it on 8?
Because in our dispatch section, they came and it was registered immediately on 10th. We can produce the original records.
Yes, let us see.
Yes.
Let us see the writ petition.
yes,
also.
yes.
Let us see the writ.
Original records will place, Lordship. Absolutely no issue.
Online reply on merits, my lord. My friend's basic contention is that it was not addressed to the government, it was sent to the deputy commissioner. My lord, was it unintelligible to the government that this is a resignation, this is not a withdrawal letter? Is it the case of the government that from the attending facts and circumstances, they were not in a position to decipher whether it is a withdrawal letter? As long as the intention is there, that is substantial compliance. The requisite intention could be gathered by the principal secretary. That's why he passed the order. Of course, on an erroneous interpretation of the legal position. Well, Article 166, that is totally in a different sphere. Article 166 argument, my learned friend did not make while opening his argument. That's why he did not reply. Article 166 is regarding authentication of the actions of the government in the name of the governor. Nevertheless, Supreme Court has said this is directed. There are series of authorities on the point. Article 166 was never construed by my Lord Honorable Supreme Court to be mandatory. It was always construed to be directed. That is the manner that I mean, it alienates the manner in which an action of the government is to be authenticated. Nothing beyond that. Here, my Lord, question is whether I had the requisite intention to withdraw my resignation and whether that intention was intelligible or it was unintelligible. It was intelligible, that's why government acted on it. Of course, there are an erroneous reasoning that it was filed beyond time. That's the only point to be decided. That's my humble submission there.
And if there is disputed facts, Lordship, then also writ petition is not maintainable.
But Mr. D. Saikia, Learned Advocate General Assam, assisted by
Assisted by yes, P. Borua, MSP Borua.
MSB Bora, Learned Counsel for the appellant, also heard Mr. K.N. Chowdhury, Learned Senior Counsel, assisted by Mr. J.M. Chowdhury. JMA Chowdhury. Learned Counsel for the respond number 1 of liquid petitioner. So, registry is directed to place the records of where the judgment.
My lord, WPC number 5583.
WBC number 5512 of 2021.
Yes.
And WBC number 5615 of 2021, which were disposed by judgment order dated 18/8/2022.
And also the original records may be requisitioned from the office, Lordship.
No, that's why we are saying that.
Yes.
Learned Advocate General Assam shall also produce the original records.
Let it come immediately on after vacation.
List on 22nd.
22nd. Highly obliged, Lordship.
Music. No file.
In this case, Lordship, my learned senior friend has something more to submit. So my reply may be given after vacation, Lordship. But day after tomorrow, can I also, it is not that.
Day after tomorrow, there will be some.
Yes.
No difficulty.
Today, in any case, I'm also facing some problem.
Okay.
Anyway, If you want to
And
submit,
then I'll take about 15-20 minutes. I'll place 2-3 judgment, that's all.
So my colleagues will be here, not.
Whether lordship will take today or day after tomorrow, my lord?
not day after
Today.
today.
Yes, I'll just rely on 2-3 judgment so that I conclude my part.
And my reply after vacation, Lord.
When do you want?
Let it be on 24th.
Not 24th, 25th, Lordship. Hello.
Book list one Lisa, na? My lord, let me articulate my points. Number one, my lord, the impugn actions has the potential of, my lord, violating the federal structure. And as my lord in Bomai's case and other case, Honorable Supreme Court has said that it is the essential feature or basic feature of the Constitution. Now, my lord, though our country is essentially, it's a federal in structure, but unitary in form. During the law days, my lord, we have learned that. Student days, we are still maintaining that. Now, the question is, what do we mean by federalism? The different organs, they must be given the autonomy to exercise their own power. Now, in spite of having a legislature, in spite of being a state within the state, if actions of that wing is to be regulated by a deputy commissioner, where is the scope of federal structure? My lord, one deputy commissioner, he is the overall now. So what will happen to the elected members of the council? What they will do? So this is how, my lord, the federal structure stands vitiated. Now, I'll just place that Bomai judgment, my lord, on this point. 1994, 3 SCC, page 1. I'll rely upon, my lord, paragraph 247. And 276. 247, 274, 275, and 276. Page 205. Please come to page 205, my lord. Federalism envisage, as your lordship's got it, my lord. Justice Goswami has got it. Yes. Federalism envisaged in the Constitution of India is a basic feature in which the Union of India is permanent within the territorial limits set in Article 1 of the Constitution and is indestructible. State is the creature of the Constitution and the law made by Article 2 to 4 with no territorial integrity, but a permanent entity with its boundary alterable by law made by the Parliament. Neither the relative importance of the legislative entries in Schedule 7, List 1 and 2 of the Constitution, nor the fiscal control by the Union per se are decisive to conclude Constitution is unitary. The respective legislative powers are traceable to Article 245 to 254. The state qua the Constitution is federal in structure and independent in its exercise of legislative and executive power. However, being the creature of the Constitution, the state has no right to secede or claim sovereignty. Qua the Union, state is quasi-federal. Both are coordinating institutions and ought to exercise their respective powers within the adjustment, understanding, and accommodation to render socio-economic and political justice to the people, to preserve and elongate the constitutional goal including secularism. So, my lord, merely because union has certain more powers, fiscal power, that does not mean, my lord, they are a superior entity. The state legislature within its domain is, is free to exercise its own power. So, field of legislation is delineated in the three lists. Concurrent list is common both to all. Same is the position with the, my lord, council. It's a constitutional setup set up within the meaning of 6th schedule of the Constitution of India. So therefore, my lord, how a council will function, it cannot be determined by the state. There's a basic misunderstanding. There's a basic fallacy in the understanding of the state, my lord. How can, my lord, unless there is a precedent rule, can Union of India tinker with the affairs of the state? Yes. In a case, in a situation envisaged by 355 and 356, when there is an external aggression, when there is an internal disturbance within the meaning of Article 355, center can certainly step in. But in ordinary circumstances, no. So in day-to-day functioning of a state, why, my lord, under the Prevention of Control Act, Corruption Act, we need, the consent of the state. Idea is to maintain the, my lord, federal structure. These are the basic ethos of the Constitution. These are the basic ideas behind the Constitution. My lord, Article 248, that's the residuary power when the power is not given to the states or the union territories. So, my lord, state cannot assume unto itself certain powers as has been done in the instant case. Now, this Boroland Autonomous Council is an absolute, my lord, autonomous body. The state cannot tinker. State cannot poke its ugly nose on it. The moment you do it, you will be, destroying the federal structure. Now, please come to, my lord. Then 248. The preamble of the Constitution is an integral part of the Constitution. Democratic form of government, federal structure, unity and integrity of the nation, secularism, socialism, social justice, judicial review are the basic features of the Constitution. The office of the governor is a vital link and channel of impartial and objective communication of working of the Constitution by the state government to the President of India. He is to ensure protection and sustenance of the constitutional process of the working of the Constitution in the state, playing an important role. As head of the executive, he should truthfully, with high degree of constitutional responsibility, inform the President that a situation is arisen in which constitutional machinery has failed and state cannot be carried on in accordance with the provisions of the Constitution with necessary factual details in a non-partisan manner. This is 356. It is under 356, governor will send the report. The affairs of the administration of the state is being run in a manner which is unbecoming of an, union, part of Union of India. Therefore, time has come. As a Union of India should assume powers. And my lord, please come to now 247-74. The federal nature of the Constitution is the heading at page 215. The expression federation or federal form of government has no fixed meaning. It broadly indicates a division of power between a central government and unit states comprised therein. No two federal constitutions are alike. Each of them, be it USA, Canada, Australia, or any other country, has its own distinct character. Each of them is the culmination of certain historical process. So is our Constitution. It is therefore futile to try to ascertain and fit our Constitution into any particular mold. It must be understood in the light of our own historical process and constitutional evolution. One thing is clear, it was not case of independent states coming together to form a federation as in the case of USA. A review of the provisions of the Constitution shows unmistakably that while creating a federation, the founding fathers wished to establish a strong center. In the light of the past history of this subcontinent, this was probably a natural an unnecessary and necessary decision. In a land as varied in India, is a strong center is perhaps necessity. Anyway, my lord, why there was more concentration of power in the central government? That has been emphasized in para 275. Now please come to 276, which is very important. The fact that under this scheme of our constitution, greater power is conferred upon the center vis-a-vis the states does not mean that states are mere appendages of the center. Within the sphere allotted to them, states are supreme. Center cannot temper their powers. More particularly, the court should not adopt an approach and interpretation which has the effect of or tend to have effect of whittling down the powers reserved to the states. It is a matter of common knowledge that over the last several decades, the trend the world over is towards strengthening the central government, be it result of advances in technology, scientific fields or otherwise, and that even in USA, the center has become far more powerful, notwithstanding the obvious bias in that constitution in favor of the states. All this must put the court on guard against any conscious whittling down of the powers of the state. My lord, I'll respectfully pray Lordship will put it otherwise. Now, please consider the legal proposition formulated in 276 in the context of State of Assam qua, my lord, the District Council, not Union of India qua the states. What is the sentence? Center cannot tamper with their powers. The last sentence, my lord. The center cannot tamper. Now I'll read. The state cannot tamper with the powers of the, my lord, District Council. Now, by appointing deputy commissioners to oversee, by doing that, what else you are doing? You are trying to dilute our powers. You are nobody. This is federalism, my lord. So, are these people unmindful or they are ignorant of all these provisions, my lord? My lord, everything cannot be judged by political considerations, my lord. It's a mighty country, my lord. It's a unity only in diversity. There are diverse peoples out there. Please, what does Article 21 guarantee, my lord? Every section of a citizen has right, fundamental right to preserve their language, culture, and, my lord, dialect. Why these guarantees are required? These are required for our upbringing. We felt, my lord, we are a group, we should be ruled by ourselves. And that is what the central government has agreed. And having agreed, my lord, this has resulted in creation of this agreement. Now, this agreement, initially it started with a positive note. Now, over a period of time, my lord, now those powers are sought to be diluted. So this cannot be permitted, my lord. So my first point is, the basic postulate of the constitution is, my lord, ours is a federation, and in a federation, merely because central government or the state government or district council enjoy more power, they are not elder brothers, my lord. They are a constitutional entity. District council is also a constitutional entity having independent powers. Nobody is supposed to interfere in each other's working until and unless it's a case of external emergency, internal disturbance, or any other extraordinary situation. And my lord, otherwise, my lord, why this devolution of power took place? It was not required. These 40 subjects were transferred. The idea was they will rule themselves. They'll be ruled by themselves, their people, not by this food. Now, what is being sought to be done is to, my lord, run this poor government. That cannot be permitted. And my lord, and most unfortunate part is the district council has not realized it. That's the most unfortunate part. That their own authority is being eroded, that they have not realized because, my lord, they are having some political power. This is the irony, my lord. Very unfortunate. Irony. That's why, but common people, they are conscientious people. The gentleman sitting behind me, my lord, he fought for more than 20, 30 years. 4-time member of parliament. They're boroughs. They feel for their own people. They should. Why not? And Assamese should feel for Assamese. The boroughs should feel for Assamese. There's nothing wrong in it, my lord. What's wrong in it? If I do not take care of Assamese interests in Assam, where do I take care? Of course, I'm in India. Of course, I'm an Assamese. But I must preserve my culture. I must preserve my identity. I must preserve my indigenous traits. Therefore, my lord, these are not to be things to be tinkered with. One has to be very sensitive. One has to be very careful, my lord. End of the day, my lord, you are trying to play with the emotion of the people. And it's a very simple, common folk, my lord. They don't understand complicated things. They want answers in a straight way. 1 + 1, 2. Not 2 - 1 - 1 is 1. That is not correct. Anyway, my lord, my first point is the impugned actions has the potential of destroying the federal fabric of the institution called district council, which cannot be permitted. The second, my lord, I'll rely on 2-3 authorities on what is now being, my lord. Now, my lord, when it comes to maintaining even a challenge to a legislation, a ground called, my lord, manifest arbitrariness has been evolved as a judicially recognized ground. I'll place 2 judgments on this point, my lord. First, that Saira Banu's case, 2017 9 SCC, page 1. My lord, 2017 9 SCC, page 1, para 101 at page 99.
Paragraph?
Para 101, my lord. Yes. It will be noticed that a constitution bench of this court in Indian Express newspaper versus Union of India stated that it was settled or that subordinate legislation can be challenged on any one of the grounds available for challenge against plenary legislation. This being the case, there is no rational distinction between the 2 types of legislation when it comes to this ground of challenge under Article 14. The test of manifest arbitrariness, therefore, as laid down in the aforesaid judgment, would apply to invalidated legislation as well as subordinate legislation under Article 14. Manifest arbitrariness, therefore, must be something done by the legislature capriciously, irrationally, or without adequate determining principle. Also, when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. We are therefore of the view that arbitrariness in the sense of manifest arbitrariness, as pointed out by us above, would apply to negate legislation as well under Article 14. Now, kindly see, my lord, how the law has advanced. Now, earlier the legal principles were it must be violative of fundamental rights or legislative competence. These are the 2 limited grounds on which a legislation would be challenged. Now, my lord, it extends to manifest arbitrariness. What is manifest arbitrariness? When in making the legislation, the determining principles are not even taken note of. Supposing, my lord, a party in power has brute majority. They come up with a legislation, it is passed by the legislature without any determining principle why that legislation was passed. Now, my lord, this is the test applicable to a legislation as well as subordinate legislation. Ours, the challenge in the present case are not legislation, these are all executive actions, which are definitely amenable to these principles. Some has the character of subordinate legislation in the sense that this will be done in this manner, this will be done in that manner. It can be said to be a primary legislation, but then it is an outcome of an exercise which suffers from the vice of manifest arbitrariness. When a legislative quasi-legislative subordinate legislation can be impeached on the ground of, my lord, manifest arbitrariness. And executive action certainly can be done. Because while issuing these orders or directions or impugn actions, which are executive in nature, my lord, it has the effect of diluting the very constitutional principles. Therefore, it suffers from the vice of manifest arbitrariness. And my lord, Saira Banu was a case lordships would recollect. It was in the context of, my lord, the triple talaq. It was a practice, not even a law. Now, my lord will kindly come to the other judgment. 2018, 10 SCC page 1. This is again, my lord, Naftez. This is regarding, my lord, article section 3 377. My lord will kindly have page 186, para 353. Page 186, para 353. Insofar as Article 14 is concerned, this court in Saira Banu has stated in para 101 that a statutory provision can be struck down on the ground of manifest arbitrariness when the provision is capricious, irrational, or without adequate determining principle, as also if it is excessive or disproportionate. We find that section 377 in penalizing consensual gay sex is manifestly arbitrary. Given the modern psychiatric studies and legislations which recognizes that gay persons and transgenders are not persons suffering from mental disorder and cannot therefore be penalized, this section must be held to be a provision which is capricious and irrational. Also, roping in such person with sentences going up to life imprisonment is clearly excessive and disproportionate, as a result of which, when applied to the such person, Article 14 and 21 of the Constitution would be clearly violated. The object sought to be achieved by the provision, namely to enforce Victorian mores upon the citizenry of India, would be out of tune with the march of the constitutional events that has since taken place, rendering the said object itself discriminatory when it seeks to single out same-sex couples and transgenders for punishment. Though it was in the context of, my lord, section 377, what I am trying to emphasize in this case is, my lord, the impugn action is so arbitrary, so manifestly, my lord, wrong, that it has the, it has the potential of, demeaning the whole concept. On one hand, you are giving autonomy, by the other hand, you are taking it back. That means you are doing something indirectly which you cannot do directly. End of the day, my lord, because of this arbitrary action, the people of the Bodolands, their guarantee under Article 14, which guarantees equal protection of law, more particularly the constitutional principle of federalism, has been denied today. This lordships will not pardon. This, in my humble submission, goes to the root of the matter. Therefore, this legislation which suffers, these actions which suffers from, manifest arbitrariness, lordships will not give any judicial imprimatur to these actions. Then, my lord, I'll rely upon that DC Wadhua's case, my lord, for the proposition that what cannot be done directly, it cannot be done indirectly, my lord. That is 491 1987 1 SCC page 378, my lord. Dr. DC Wadhua versus State of Bihar. My lord, this was a case relating to, my lord, promulgation of Article 312 and 13 ordinances, Bihar case. Successive promulgation of ordinances in exercise of power under Article 213. Yeah. Now, my lord, the para 7 starts at page 391. It's a very, very long para, but I will have your lordship's kind attention to last part of my lord, para 7 at page 393. And line about 1, 2, 3, 4, 5, 6. Line about 7 before the my lord quotation. The sentence starting with, it is a settled law. It is a settled law that a constitutional authority cannot do indirectly what is not permitted to do directly. If there is a constitutional provision inhibiting the constitutional authority from doing an act, such provision cannot be allowed to be defeated by adoption of any subterfuge. This would be clearly a fraud on the constitutional provision. It's very, very important. In fact, the power which has been exercised to dilute the powers of the my lord district council is a fraud on the constitution. My lord, state of Assam cannot regard that we are a higher authority and district council is a subordinate authority. No. Wadi district council area, district council is supreme. Yes. Wadi state, state is supreme. Therefore, you cannot have that elder brotherly feeling, I'll do whatever I like. End of the day, where do people go, my lord? When everybody is dancing to the tune of the politicians, what does the common people do, my lord? Everybody do not have the resource to come to your lordships. Therefore, many conscientious people who feel for their, my lord, own interest, there before your lordships, espousing a very, very important public cause. What is that cause? That there was an huge agitation for 3-4 decades. There was insurgency, which ended, which culminated into an first accord, followed by the second accord, followed by constitutional amendment, followed by, my lord, creation of an autonomous district council. Now, those powers of those councils are now sought to be truncated in a manner which directly they cannot do. They are trying to do something indirect. Therefore, it's a fraud on the exercise of power. Finally, my lord, one judgment, AR 1967, Supreme Court 1427. This is basically a judgment for the proposition, my lord, that there is nothing like arbitrary exercise. There cannot be, no authority can possess arbitrary power. Whosoever exercises it, it is required to be, my lord, interfered with. Para 14. In other words, my lord, these arbitrary actions are not immune, my lord. There is no immunity in favor of an action which is otherwise arbitrary. Para 14, my lord. In this context, it is important to emphasize that absence of arbitrary power.
No, something is wrong.
My lord, my lord, sometimes what? No, my lord, as G. Jaisinghani versus Union of India. Oh, my lord, the sentence starting with, it is in this, sometimes paragraphs do not. In this context, it is important to emphasize. Yes.
21.
Okay, man. At least you have a difference of 7 paragraphs. In this context, it is important to emphasize that the absence of arbitrary power is the first essential of rule of law upon which our whole constitutional system is based. In a system governed by rule of law, discretion when conferred upon executive authorities must be confined within clearly defined limits. The rule of law from this point of view means the decision should be made by application of known principles and rules, and in general, such decisions should be predictable and citizens should know where he is. If decision is taken without any principle, without any rule, it is unpredictable, and such a decision is antithesis of a decision taken in accordance with rule of law. Law has reached its finest moment, stated Douglas J. in so-and-so, when it has freed man from unlimited discretion of some ruler. Where discretion is absolute, man has always suffered. It is in this sense that rule of law may be said to be the sworn enemy of caprice. Discretion, as Lord Mansfield slated in its classic term, is a case of John Wilkes, means sound discretion guided by law. It must be governed by rule, not by humor. It must not be arbitrary, vague, and fanciful. Now, my lord, the impugn notifications which were put to challenge, is it backed by any governing principle? Is it consistent with the constitutional ethos? Is it consistent with the federalism? My lord, state may think that we would like to retain control over the activities of the district council. But my lord, it must be permitted by the constitution. Which is that provision? Which permits you? End of the day, lordships will try to find out if any action is. My lord, Honorable Supreme Court has also said, supposing exercise of power is traceable to a legitimate source. Now this source is not mentioned in the order impugned. Then also Supreme Court said, as long as the action is relatable to some source, even though it is not mentioned, court will save it. But which is that authority, source, exercising which we have issued all these impugned notifications? My lord, lordship will kindly appreciate, your lordships or the courts in India in the field of administrative law has also said that supposing a power is given to do certain things, that power is not exhaustive, but certain incidental or ancillary powers are required to make the grant complete. The Supreme Court has said, in such a situation, authority is presumed to have ancillary and incidental power. But my lord, there must be some source. It is regarding incidental and ancillary power you can, derive from some basic source. But to retain supremacy over somebody, then it must be conferred by the Constitution. If you think I am State of Assam, District Council, Borough Autonomous Council is an authority which is subordinate to me, then the Constitution must recognize that principle. If it does not, then State of Assam do not have the power. So these are my humble submissions, my lord. Subject to what the learned Advocate General argues, I'll give a reply. Otherwise, my lord, this is my basic submission. They cannot tinker with the powers of the District Council. It is unfortunate the District Council should have been before your lordships to file this petition or file a suit under the constitutional scheme of Article 132. Suit. They have not done it. But we, as a, my lord, signatory of the first Borough Accord, we were the stakeholders, my lord. We are before your lordships. Because it is our blood and toil which has given result of this. So we cannot see, my lord, it being whittled down by some over-ambitious politicians. Sorry, we can't agree to that. And we are the signatories, my lord. Petitioner number 3 to 9 are all signatory to the accord, second Borough Accord. That is my humble submission.
Heard Mr. P.N. Chaudhary, Senior Counsel, assisted by Mr. M. Goswami, Learned Counsel for the petitions. Also heard Mr. R.K.T. Chaudhary, Learned Deputy Solicitor General of India for response number 1. And Mr. S. R. Raba, Learned Standing Counsel for response number 8. On request, Madam, we have Mr. D. Saikia, Leonard Advocate General, this the matter on 24th, he said.
Lordship, 25th. 25th.
Was it 24th or 25th?
Lordship, 25th.
25th of January. 2024. For further hearing.
My lord, remain as part heard, my lord. Lordship has heard my part.
Okay, then you say, on the matter is kept, part heard.
Deep lord. Register note put up for you,
You make photocopies of this and receipt on the court.